For the petitioner, this matter, my lord, group 2 matters, my lord, wrongly appear in the list, my lord.
আসো কি হলো কি হয়েছিল ঠিক আছে সব ঠিক আছে তো চল বাড়ির খবর সব ঠিক আছে তো চল মিস্টার
Ashish Kumar Pal.
Ashish Kumar Pal, learned advocate, appears for the petitioner. Paragraph. None appears for the respondents. Paragraph. Learned advocate for the petitioner submits that this writ petition pertains to bold group dash Roman 2 এই কথাটা bold of the classification list. Paragraph. Due to want of determination, this writ petition is directed to go out of the list of this court and to appear before the appropriate bench.
Yes,
Full
ma'am.
stop. The records are directed to be sent before the appropriate bench forthwith.
Yes, ma'am. Or appropriate department to send the department.
Chalo.
Item number 2, Your Lordship, I am appearing on behalf of the petitioner.
Application for
Lordship, this is in relation to the LICI, Life Insurance Corporation of India matters. Lordship, usually
wait 5 নম্বর কেন আজকে কোনটা আছে
can 6, Your Lordship.
any interim order passed earlier
Earlier, not with regard to this show cause notice. Not with regard to
in this writ petition any order passed earlier
Lordship, interim order were passed earlier with regard to earlier show cause notices.
in
But-
this writ petition
In this writ petition, Your Lordship.
earlier show cause in
Yes,
this
my lord. My lord, may I just indicate this thing? If my lord kindly takes the writ petition and kindly sees the prayer at page 40. That the
what happened to my order
My lord, this week.
because yesterday also I passed the same order
No, my lord, that is absolutely fine, my lord. My lord,
I am also fine with that. You statutory remedy you can
absolutely.
I don't mind for that
My lord, otherwise I would not have stand in the way in passing the similar order in this matter. The only preliminary objection which I have is page 40 of the writ petition. The writ is confined only to the show cause notice that was issued way back in 2022. That has been
no
stated.
sir kindly take prayer B
Yes. That challenging the virus is already there. Now, my lord, this second show cause notice is obviously for a subsequent year.
I will not pass that order. I will pass my usual order.
Very,
I will pass my usual order.
very well.
They shall proceed, but they will not,
Not
pass
to
the
give any
final
work.
result.
Lordship.
My lord,
Ashu.
for my lord's convenience, I'm-
Yesterday I passed an order. Bring that. Yes. Where is the yesterday's one?
Yes.
That is more precise because of the subsequent development.
Yes. In that even I am not carrying that one. I'm
No
extremely sorry.
problem. And what is this? Better you by that time you show me the application. শুনুন কাল যে অর্ডারটা করেছি সিরিয়াল নাম্বার লিস্টটা বের করুন ওই মোশন টপে ওই উজ্জ্বল রায়ের যেটা কাল যে অর্ডারটা পাস করেছি লিস্টটা কালকের বের করুন মোশন টপ বের করতে বলুন দিদিকে কালকের অর্ডারটা show me the application sir what do you want to say on application why
Okay.
this application
This application, Lordship, is assailing a new show cause notice.
new show cause
New
notice
show cause notice that has been served upon me this year.
it's a new cause of action how
Lordship,
can it act?
Exactly, my lord.
Lordship, in the previous occasion in 2024, when I was served another a similar show cause notice and then a termination notice, I made the submission that since a stay was pending on a similar show cause notice and such stay was not vacated nor any leave of the court was taken, The cause of action in the main writ petition is still subsisting.
Absolutely subsisting.
A coordinate bench,
But that cause of action does not include the second show cause.
Lordship, the coordinate bench of this honorable court in the
No, but one thing you can say
Accepted
that
this.
in the parent writ petition, you have challenged the virus of the rule.
Lordship,
So this is in aid of that.
Lordship. Lordship, may kindly comes to
Not required.
Annexure D, which is at page 24. Lordship, may kindly consider the order that was previously passed.
And just show me the order passed in your writ petition. What
Lordship,
was the order passed in your writ
it
petition?
is in Annexure
What is the interim order passed in your writ petition?
Annexure A, your Lordship, at page 18 of the application. Starts at page 18.
Application. Application annexure A, page 15 is something different. I am saying what was the order passed?
18, your Lordship.
I don't, 18.
18.
Yes.
This was the original order passed.
Wait.
The effective portion is at page 20.
No, perhaps that is not correct. My lord, kindly sees the order dated 25th of April 2023. Order, the first order was passed much prior to that.
That was the first order. No,
So-
stay there.
The honorable court is asking when the first order was passed.
No, first day was passed.
First order in your writ petition.
First order in the writ petition was passed on 25th of April, which is at page 16.
No scope for any interim order.
Lordship, then Lordship may kindly comes to page 18, the subsequent order. Lordship may
Alright.
kindly.
Mr. Go, they're in aid of the writ
My lord,
petition.
I don't stand in the way. I don't stand. It is
Lordship, may
completely,
kindly.
I had to take the points I have already indicated. My lord may kindly.
কি হলো কি হচ্ছে প্রিন্টারে কেন আসছে বলুন তো ডেকে পাঠান এই পাতাগুলো সঙ্গে রাখুন
Lordship,
ওদের দেখাতে হবে
we have a copy of this order,
yesterday's
not yesterday, it's 14th July
no I want an yesterday's order
in 14 WPA number, which is being shown in the screen. 14 July.
no no কালকের অর্ডারটা
আজকে কত তারিখ?
কাল কি 14 ছিল
হ্যাঁ, এটাই।
তো তাহলে তো আছে তো তোমার কাছে।
ও তাহলে ছেড়ে দিন কাল 14 ছিল দিন
The
দিন দিন
learned friend was already carrying this order. আরেকটা কপি আছে।
একটা copy আছে। Lordship, the first order passed, this honorable court was pleased to hold that the writ was premature at that point of time, since no notice of termination had been.
এইটা একটু দিন দুজনকে আমি টিক মেরে দিয়েছি সেকেন্ড পেজ থেকে একটু দেখে নিন ছেড়ে দিন আপনি লোক ডাকুন বলুন ওইগুলো দেখাবেন প্রিন্ট আউট you are looking at
Lordship,
Well,
Lordship.
আগে একটু জুড়তে হবে আসুন। Now you listen, first part I am dictating. Can 6 in re can 6 of 2025. আচ্ছা তার মাথার উপর লিখুন your name
Lordship Deborshi Das.
Deborshi Das, learned advocate, appears for the petitioner. Mr. Abhishek Guo, learned counsel, appears for LICI with
Mr. Shubhajit Das.
Mr. Shubhajit Das, learned advocate. He is very competent. He does very well. None appears for Union of India. এবার লিখুন এবার ইন রে আচ্ছা মাথার ওপর ইন রে ক্যান করেছেন তো অ্যাপিয়ারেন্স করেছেন এবার লিখুন অ্যাফিডেভিট অফ সার্ভিস ফাইলড ইন কোর্ট টুডে ইজ টেকেন অন রেকর্ড বাবা একটু কমিয়ে দাও টাকাটা বুঝতে This is an interlocutory application filed in the pending parent writ petition with the following prayers. Quote 1 from page 11, prayer A to F, A to G to the application. ঠিক আছে? Quote 1. Paragraph. Prayers B and C, small b and small c. First bracket এর মধ্যে দুটোই bold হবে। Prayers থেকে bold হবে। Prayers B and C, ওই of the bold. From the writ petition are also quoted below. Full stop. কি হলো কি হলো বলুন তো রাখুন তো কে বললো আমাকে একটু ডাকবেন তো তখন যাই হোক ঠিক আছে কিচ্ছু হবে না ও আবার ওটা 3 দিন বাদে আবার এরকম হবে ওটাকেও বললো আবার দিয়ে আসো গাড়িতে জল লাগলে আর কি হবে চলুন ঠিক আছে বলে আপনি চেঞ্জ করিয়ে নিন দিদি এক্ষুনি কি বল আচ্ছা এবার এইটা সেট আউট করুন Your name, sir? Mr.
Amit Pal.
Your name?
Deborshi Das.
Deborshi Das.
Yes.
How do you spell out?
Debarshi.
Abhishek Guho. Spell out
AVISHEK.
A-V,
Yes, my lord.
A-V-I-S-H.
EK. Yeah.
এখানে একটা অ্যাড করুন। Mr. Abhishek Guho, rider. Rider A. Mr. Abhishek Guho, learned counsel for LICI, further submits that through this application, the writ petitioner has challenged the second show cause notice dated third show cause notice dated June 16, 2025. Post. This was not the subject matter in the writ petition, right?
Yes, my lord.
Post. Rider B. B. ঠিক আছে? It further appears to this court that the relevant rules are under challenge in the parent writ petition. The third show cause notice dated June 16, 2025 has also been issued in aid thereof. Poster. Thus, if the writ petition succeeds on merit, comma, automatically the said third show cause notice will lose its force. This court is of the view that in such fact situation, that comma, in such fact situation, comma, if any order is passed in the parent writ petition, the same shall also be in force in respect of, and same shall also be in force and shall govern the said third show cause notice. Post. তারপর এখান থেকে যা আছে পুরো চেপে দেবেন। ঠিক আছে, দেখুন এই দুটো জায়গায় রাইডার এ রাইডার বি ঢুকে যাবে। যা করে দিয়েছি দেখুন সামনের দিকে কারেকশন করেছি। ঠিক আছে, ঠিক আছে, থ্যাংক ইউ, থ্যাংক ইউ। কোন ডেট? হ্যাঁ, কারণ অগস্টে সুপ্রিম কোর্টে আছে না। এনে আপনি ধরবেন না, পারবেন না, হাতে লেগে যাবে।
My lord, I'm appearing for the
Let me, Mr.
petitioner, my
Muthuda.
lord. My lord,
I would be
yesterday,
seeking
my lord.
Password, my lord. Very short password. We have the instructions, my lord. Your lordship on the yesterday had asked us, my lord, to inquire that what would be the rank of this particular petitioner and who would be the deciding authority. My lord, we have done that. He's a subordinate officer, and the DIG respondent
DIG,
number
my
3
lord.
would be the person who would be deciding his grievance.
Passing the
My lord,
order.
I'm only beseeching, my lord, that he may decide it within a period of 5 weeks, or whatever your lord.
6 weeks.
6 deep period. Deep period. And my lord, the point of maintainability that your lordship had, my lord, indicated, the territorial jurisdiction, that
I
will also
make my observation.
deep period.
My lord.
And with regard to the future time when he approaches, this should be a point which should be considered.
That I will mention, of
Deep-
course.
Deep period. Deep period.
Ashu, you listen to me.
Deep period. Yes, I will do.
Has your senior come to court?
My lord, he is on his way. My lord, he is another court, but he is appearing on another court. He's on his legs.
No, he is in the court premises.
Court premises, my lord.
Give his name.
Deep period.
Your senior is there. Anybody? All right. এটা এইটা অর্ডার ফর্মে হবে। হ্যাঁ, এটা জাজমেন্ট অর্ডার না, মানে আপনি লম্বা কাগজে করবেন কিন্তু আপলোড করবেন জাজমেন্ট। This is a hearing matter on affidavits. Second paragraph. The petitioner the first petitioner is the wife of the second petitioner. The second petitioner is working as,
Sub-Inspector General Duty at
wait.
Mal.
Working as sub-inspector, bold হবে এখান থেকে, sub-inspector,
General Duty,
comma, general duty,
bracket. General Duty, my lord, at 30th Battalion,
at 38th,
38.
38তম 38th Battalion,
posted at Raipur, Chhattisgarh,
ITBP,
ITBP, Indo-Tibetan Border Police Force.
30th Battalion, Indo, ICAP, Tibetan, TCAP, Border, BCAP,
Police
Police,
Force.
PCAP Force. F cap, bracket ITBPF, bold. At
Raipur, Chhattisgarh.
Raipur, Chhattisgarh. The petitioner was transferred to
54th.
From 54th Battalion to 38th Battalion.
No, no. From the 38th Battalion to the 54th Battalion.
Presently posted as in 30th Battalion.
Yeah, he's not yet transferred. He has not joined the duty.
Malad, he is presently posted at 30th Battalion, Malad.
আচ্ছা কি
He
লিখবে?
was earlier at
দাঁড়াও
54th
দাঁড়াও আস্তে আস্তে করো
Malad.
কি বললাম is presently working as হয়ে গেল
হুম।
হয়ে গিয়ে ফুল স্টপ করে দাও ওই প্যারাগ্রাফ পরের প্যারাগ্রাফ
Malad.
previously the petitioner was transferred from 38th battalion to 58th battalion.
No, Malad. Malad, in the year 2019, he joined in 54th Battalion ITBP.
আচ্ছা one second,
Then
one second, one
transfer-
second, slowly
Malad.
কেটে দিন next. In 2019 the petitioner number 2 joined at
Indo-Tibetan Border Police Force,
which battalion?
54th Battalion.
54th battalion. Full stop.
Then transferred to
Then he was full stop. Then he was transferred to
38th Battalion.
38th battalion and presently working there at full stop. Now what did you challenge?
Malad, I have challenged Malad three things, Malad. One is Malad, the extraordinary leave, Malad. Malad, second is Malad, the
So
transfer
you are made unauthorized absence.
absence.
এবার আসুন চলো প্যারাগ্রাফে চলে আসুন paragraph. It was alleged by the respondent's employer that the petitioner avoided on the one pretext or the other to join the transferred places. Full stop. It was further alleged that the petitioner did not undergo a training program which was a mandatory requirement, which was a mandatory requirement. As a consequence, the petitioner has disciplinary proceeding initiated or what?
No discipline.
Then what?
Malad, they were not letting me to join in any Malad course, Malad, or Malad, they were not letting me do the job, do my duty, Malad, before their Malad, and
You
they
have
were
kept him,
continuously
you
harassing.
kept him in abeyance or what?
No, my lord, that is not the case which he has been making out. Your Lordship, can you see the 5th October order? My lord, there are three points that has been raised by him.
5th October, yes.
5th October order, my lord.
I am that, Malad. I am on that only.
The first issue is relating to petitioner's transfer from 38th Battalion to elsewhere, particularly in view of the conduct of the commandment of
কোথায়?
my lord, the 5th October order, page number 2.
Hmm.
The first line, my lord, it appears that the petitioner has threefold grievances which he has.
আসুন. From the writ petition, it appears, as was also recorded by a coordinate bench in its order dated October 5, 2024, that the petitioner has threefold grievances. which he has ventilated through this writ petition. First, the first is relating to petitioner's transfer from 38th Battalion to elsewhere, particularly in view of the conduct of the commandant of such battalion towards the petitioner number 2. Full stop. The second is that the pay scale of the petitioner has been arbitrarily reduced. Full stop. Third is that the representation of the petitioner has not been considered. First paragraph. The order dated October 5, 2024 shows that at the outset, the respondents have taken the point of territorial jurisdiction on the plea that the entire cause of action arose beyond the territorial jurisdiction of this High Court, and the respondents also have their offices wherefrom steps were taken against the petitioner, alleged steps were taken against the petitioner, are also situated beyond the territorial jurisdiction of this High Court. On the solitary plea that the permanent resident of the petitioner number 2 being at Chinsura, within the jurisdiction of this court, the writ petition was entertained without dismissing the same on the ground of lack of territorial jurisdiction. First paragraph. Pursuant to the directions made by the coordinate bench, parties have filed and exchanged their respective affidavits in opposition. Parties have filed and exchanged their affidavit in opposition and reply thereto. Paragraph. After hearing the rival contentions of the parties and upon perusal of the materials on record, it appears to this court that while examining the grievance of the petitioner in the light of the stand taken by the respondents through their affidavit in opposition, a detailed fact-finding inquiry is required to be made, for which the appropriate departmental authority, should be the appropriate authority to decide the issue with reasons by disclosing the supportive materials in support of their reasons at this stage. Poster. Thereafter, at this stage, full stop. Paragraph. In view of the above, the respondent number
3. The DIG SHQ, my lord.
Respondent number 3 In view of the above, the petitioner shall serve a copy of the writ petition, affidavit in opposition and affidavit in reply, along with a copy of today's order and the previous orders, upon the respondent number 3 forthwith. First paragraph. The respondent number 3 then, upon issuing a prior hearing notice of at least 2 weeks, to the petitioner, and after petitioner number 2 weeks, to the petitioner number 2, upon the petitioner number 2, and after granting him an opportunity of hearing, shall decide the issue in the light of the pleadings to be served upon him by passing a reasoned order in accordance with law. Paragraph. The entire exercise shall be carried out and completed by the respondent number 3 positively within a period of 6 weeks from the date of communication of this order. The reasoned order then, full stop and pause. The reasoned order then shall be served upon the petitioner positively within a further period of 2 weeks from the date of the said reasoned order to be passed. Paragraph. It is made clear that this court has not gone into the merits of the claim of the petitioner and the writ petition, and the petitioner shall be at liberty to urge his points before the all his points before the respondent number 3, but the same shall not travel beyond the scope of the writ petition. Paragraph. It is needless to mention that the petitioner shall be entitled to be accompanied with his duly authorized representative.
No, my lord, over here, my lord, he should be heard in person, my lord.
Oh,
Should be heard in person.
বাদ দাও, ছেড়ে দিন ওটা, ফুল স্টপ হয়ে গেল। প্যারাগ্রাফ। While passing the reasoned order, the respondent number 3 shall also disclose and refer to the supporting materials in support of his reasons. Full stop. But the same shall next. In the event the reasoned order goes in favor of the petitioner, then the appropriate authority shall take all necessary and consequential steps.
Lord, only my lord may not add that because my lord, let him decide, my lord. Then if my lord need be, they'll act in accordance with the. But based on the outcome of my lord, based
That's right, I'm saying that.
any outcome, my lord, they'll act in accordance with.
I'm saying that কি বলেছি পড়ুন?
In favor.
No, no, if in the event. In the event. If in the event the reasoned order goes in favor, appropriate authority / authorities shall take all necessary and consequential steps in accordance with law to give an immediate effect thereto, but positively within a period of 4 weeks. এই period গুলো সব bold থাকবে. From the date of the said reasoned order to be passed. Paragraph. It is further made clear that this order shall not create any right or equity in favor of the petitioner if the petitioner does not succeed to his claim before the respondent number 3 strictly in accordance with law. Paragraph. It is also made clear that if a further challenge comes on the reasoned order to be passed from the end of the petitioner, then the respondents shall be at liberty to take the point of jurisdiction কি বললাম shall be at liberty to raise the point of territorial jurisdiction, the point of jurisdiction, comma, if so advised.
My lord, only two parts, my lord. I did not want to trouble your lordship while dictation. My lord, one is one of our submissions, my lord, if it could be added, that the unauthorized absence did not have any supporting cogent medical document. My lord, your lordship has recorded one submission of ours that he did not undergo the mandatory training program. My lord, another submission over there.
The mandatory training program আছে না?
Yes, over there.
ওইখানে আরেকটা sentence
Malad, before
Because
that,
we've
Malad,
taken-
I have submitted each and every document. Malad,
No
let them
cogent-
consider, Malad.
Very well.
Very
Very well. And my lord,
and I have limited.
and secondly, my lord, yes, my lord,
I have limited only the petition
Petition-
opposition reply.
my lord, the only, my lord, the second point is that they will not pray for an adjournment on the date so fixed for his hearing.
No, we will not.
Let that be an undertaking
not.
recorded by him. Because otherwise, my lord, then they will take an
কি
adjournment,
বললাম,
that
কি
6 week
বললাম, কি
period will
বললাম?
not be able to be done.
না ওইখানে চলে যান ওই 6 weeks 2 weeks.
Malad, but Malad, in my most respectful submission, Malad, uncertainty can happen, Malad. I am not on that.
I will provide that, don't worry.
That is the only reason why I pointed.
We will not take, Malad, intentional adjournment, Malad.
Without granting any unnecessary adjournment to either of the parties.
Debrief.
6 weeks হলো তো from the date of communication of this order, without granting any unnecessary adjournment to the parties. Granting any unnecessary adjournment to the parties. হলো? Paragraph. Last. With the above observation and direction, this writ petition, bold, WPA 17671 of 2024 stands disposed of, comma, without any order as to cause.
Debrief.
মাথার উপর ওই appearance এ লিখতে দিন। রাজদীপ মজুমদার, ওই যে ওর নামটা লিখেছেন না? রেসপন্ডেন্টের হয়ে কি লিখেছেন বলুন? লিখে দেবেন ওরা। You give the names, all
Yes,
the
sir,
names.
already given. Give this. Debrief.
Deeply obliged, Malad.
Report I am for the petition.
Your Lordship, Mr. Krishnadas Poddar is appearing on behalf of the state. I have instructions from him to pray to your Lordship for a Passover, as he is engaged in another court.
If he does not have, you pursue him.
They are
এটা কি motion top নাকি?
there are
Motion top.
other courts are there, my
Oh, sorry, it is motion service.
service.
ও ফরওয়ার্ডার্সটা হয়ে গেল।
হ্যাঁ।
ঠিক আছে।
Passover,
Pursue him.
my lord, there are other courts, my lord, we have to attend, my lord. That's the
Passed over for the day.
day means, my lord, my client will suffer, my lord. I'm suffering.
Wait, the list will, the matter will remain in tomorrow's list, but yes, of course, it's up to you. Up to you. I am not here to. If you don't concede, don't concede.
আরে request the clients শুনছেন না তো আমি কি করব?
I don't believe in that Passover for 10 minutes or 2.5 minutes. Either it is passed over for the day or you do have to do the
It
matter.
will retain its position, my lord. It will retain its position, my lord, tomorrow.
No, Mr. Counsel, matter will definitely will be in the list tomorrow. But if new matters are added, it will add.
My lord, may I proceed, my lord? Then?
I don't mind, sir. It's up to you. Between yourself. Yes.
Fileটা দিয়েছো? The petitioner's father was the employee of the my lord under the district judgeship of Bankura, my lord. He was the head clerk.
Where is the district judgeship or district representation?
My lord, the state is appearing.
State is not the
I have
district
served all.
judiciary.
I have served all.
High Court administration served, but none appears. Acha. No, then I cannot take up. I will
District
pass it
judge I
on.
have served, my lord. The principal accountant general I have served. Treasury officer I have served.
What is the urgency you have?
Urgency, my lord. Here, my lord, my family pension has been turned down.
Serve and come back.
My lord, I have served already.
But they are not appearing. I must hear them.
Then, my lord, kindly fix a date, my lord.
Let me see. কি বললাম? See the order. Listen to the order. Mr.
Shomik Ganguly.
Shouvik Ganguly, learned advocate. Shoumik Ganguly, learned advocate, appears for the petitioner. আচ্ছা, তার মাথার উপর লিখুন। None appears. না, তার মাথার উপর affidavit of service. Where is that, sir?
Well.
Filed in court today is taken on record. Paragraph. None appears for the respondents, comma, despite notice. None appears for the respondents, comma, despite notice. Full stop. Considering the issue involved in this writ petition, comma, there is no scope, comma, there is no scope for interim order, any interim order. Full stop. Opportunity should be given, one more opportunity should be given to the relevant district judiciary and the High Court administration. Which respondent, sir?
My lord, respondent number 2. 2 and 5, my lord.
No, High Court administration is not a party.
No, no, no.
All right. তাহলে কি বললাম? Opportunity.
কত তারিখ?
No, to the relevant district judiciary. Post up. And along with other respondents. Paragraph. In view of the above, the petitioner shall serve one more notice along with a copy of today's order upon the respondents and shall file an affidavit of service when the matter shall be taken up next. Paragraph. It is made clear, if the respondents are not represented on the next day, the court may proceed in their absence. The writ petition shall appear under the heading motion service on. আজকে কত?
আজকে হচ্ছে 15.
Tell me.
Or any date suits your lordship.
No, you have to serve now.
One week, my lord, it will. Because the
30th.
state has been served.
July 30.
July 30, my lord, I have difficulty.
Difficult. July 31.
Not that too.
31.
From my lord,
Acha. 29.
29 is a Friday.
না, Friday রাখবো না, Tuesday.
Yes.
July 29, 2025.
July 21.
Motion service under the heading. আচ্ছা শুনুন, ওইটা সব ঠিক আছে, সব আমি কারেকশন করে দিয়েছি। একটা অরেঞ্জ ট্যাগ মারা আছে যে পাতাটা, ওইখানে ওই ডিকটেশন, হ্যাঁ একবার আসবেন আমি বুঝিয়ে দেবো, কিছু না। ওই অ্যানেক্সারে যে ডিভিশন বেঞ্চের জাজমেন্টটা অ্যানেক্স করা আছে, he has also relied upon in the matter of he has also relied upon a decision of the honorable division bench dated such and such. আর দূর, আপনি 100টা বলেছেন। He has also, the learned counsel has also relied upon the decision of the honorable division bench dated such and such in the matter of XSY rendered in. বুঝতেই পারছি না ওটা। ওইটা দেখতে হবে, দেখে নাও, আসুন না। অত বড় জাজমেন্ট দিয়ে দিয়েছি, কোর্টে শেষ করে দিয়েছি, আবার কি সার্ভার করে দেবো?
My lord, I appear for the State Fisheries Development Corporation. State respondent.
And for the rest, petitioner.
You're for the petitioner.
Lordship, my report may be
Key
taken on record,
report. Exception.
not filed.
Not record, madam. We have worked, we are not being paid. We have worked, we are not being paid.
My lord, we are disputing that they have worked, my lord. As per my instructions, they have not worked for the period they are claiming the wages. At first, my lord, their
Any attendance register maintained?
any attendant register they have annexed, my lord, having no seal and no stamp of the company, your lordship. In fact, no signature of the project in charge, your lordship, and that is being disputed. My lord, we are saying no formal letter of engagement were given to them. They are the local residents, my lord, who are engaged project
Why
wise.
to any reason order passed
No,
from
your
your end?
lordship. No, your lordship.
So better this fact
We
finding
happen to-
inquiry I will not do.
My lord, these are disputed question of
First
facts,
thing,
your
the
lordship.
first question comes to my mind, Mr. Ahmed, how the employee could get the attendance register? I'm not disputing the content or factum or the veracity of it. I am an employee. The attendance register is strictly to be maintained with the employer. He may be asked to produce. How the petitioner being an employee can
From
disclose?
the employer. From the employer.
From?
From the employer.
Not believable.
Lad, I tell you, Lordship, lad, this is not the first time. Lad, since 2016, I was doing the matter. Lad. More, a large section of these people, lad, has now been regularized by court's order. Now, lad, they are working in different projects. But we have annexed a letter of lad, SFDC, lad, work karo. Lad, where, lad, kindly look to the order, lad, what they are saying now and what they have stated in 2021 is something different.
No, maybe. I am only concerned with
I am
this petition.
absolutely constitutional issue, lad, whether they have a right to exploit me.
I am on this writ petition. On this writ petition. So you show me your case from the writ petition.
Kindly take
And
some,
I
lad,
shall consider their report.
take some, lad, page 111.
Who will succeed will succeed.
Page 111, lad.
Ashu,
Lad, this may
one
take,
second.
this may take some time, lad. Can it be taken up on any other day, lad?
And our report has already been filed on the last occasions.
That I don't mind. You're welcome.
Can it be taken up any other day?
That I don't mind. Ashu,
I'll
just one
sit.
by one, one by one. Mr. Shamim Ahmed, Learned Counsel, appears for the petitioner. MS Tulisina, Learned Counsel, appears for the respondent number 1/state. MS
Porna Roy Chaudhary,
Porna Roy Chaudhary, Learned Counsel, appears for respondent number
2 and 3.
2 and 3. Paragraph. On the prayer of the Learned Counsel for the respondent number 2 and 3, time to file report in the form of affidavit stands extended till today, full stop. The report filed in court today is taken on record, full stop. Copy has been served upon the petitioner. Full stop. Since you are taking time, I can give you another opportunity to file exception. Full stop. Copy of the report has been served upon Mr. Ahmed today in court. Full stop. The petitioner shall be at liberty to file its exception in the form of paragraph Didi. Petitioner shall be at liberty to file its exception in the form of affidavit to the report on or before
7 days.
On or before July 23, 2025, upon a copy being furnished to MS Rai Chaudhary, Learned Advocate. Where is your report?
It has been filed much earlier.
Ah. No, State Fisheries Development Corporation Limited.
My lord, I have filed an earlier report for the clarity, my lord. Another report has been filed pursuant to the order.
So
of
you
lordships.
want to file exception to both the report? ওখানে কি বললাম? না তার আগে লিখুন পড়না রয়েছে on the prayer of such and such করে আজকে রেকর্ডে নিলাম. Copy has been served on court. The earlier report in the form of affidavit affirmed on April 2, 2025, filed on behalf of respondent number 2 and 3 is already on record. তারপরে লিখুন মিস্টার শামীম আহমেদ, ওই যেটা বলেছি, কি বলেছি?
অনেক আগে ফাইল আছে।
To both the said reports. আবার পড়ুন. The petitioner shall be at liberty. Composite exception. হয়ে গেল, আর বলার দরকার দাঁড়ান, স্টেটেডটা দেখি। Yes. The report filed in the form of affidavit affirmed on March 4, 2025 on behalf of the respondent number 1 is already on record. Paragraph. Petitioner shall also be at liberty to file an exception to the said report filed by the state by way of an affidavit on or before the same day as directed above. Paragraph. The heading আছে
Motion.
the writ petition shall appear under the heading motion service on August 2.
August Saturday.
Yes, we are open.
Lordship,
Huh?
Lordship, kindly. না না।
That's why I can come.
I have no
1st
difficulty.
August, 1st August হোক
I have
Friday.
no difficulty.
Then what do we do? Madam, what do we do? If nobody comes,
Lordship, maybe there will be resolution.
so what? August 6, 2025.
My lord, item number 6 হতো আছে।
Same on record.
হ্যাঁ,
কি?
my lord, item number 6 is also same, my lord. I am filing.
Who is there?
My lord, my learned senior is বলো petitioner এর জন্য।
কে আছে কে?
I am for the state, my lord, led by KJ Yusuf, Mr.
Wait. Previously you filed a report.
Yes,
Yes, my lord,
Same
same
situation.
situation.
and my lord,
তো শুনুন,
report apart
ওই
from-
পরেরটায় না আর ডেট ফিট দেওয়ার দরকার নেই,
Tag করে দিলেই হয়।
সেম হয়ে যাবে। শামীম আহমেদ এক, পর্ণা রায়চৌধুরী এক, স্টেটের হয়ে শুধু পাল্টে যাবে মিস্টার
KJ Yusuf,
স্যার ইউ গিভ ইয়োর নেম
Porikshit Goswami, my lord, Porikshit Goswami.
Mr. Porikshit Goswami, learned advocate, led by Mr. K.J. Yusuf, learned advocate, appears for the state. করে সেম করে ছেড়ে দিন, শুধু ওই অ্যাফার্ম ডাউন যে ডেট গুলো আছে না
Affirm,
ওগুলো
my
আর
lord,
বলার দরকার নেই।
Our report affirm on 3rd April, my lord.
3rd April লিখে দিন, 1st April নয়,
এই 6
April 3, 2025.
Yes. And filed
Ah.
on, my lord, on the last order, it was filed before my lord.
ঠিক আছে।
চলো।
Yeah, বলে দিলাম।
Grateful to you.
Lordship, I appear for the respondent 1, 2, and 3 in this matter, Lordship.
I appearing on behalf of the petitioner, I have been led by Mr. Raghunath Chakraborty.
হ্যাঁ,
Mr. Raghunath Chakraborty. He is due to some personal difficulty, he is not able to come today. My lord, kindly.
ফার্স্ট ওভার ফর দ্য ডে।
My lord, I am appearing for the petitioner in this matter, my lord.
Why people state respondent?
This is my affidavit of service.
Yes.
The petitioner joined his service to the post of typist copyist in criminal copying department, my lord, under establishment of learned ACJM, my lord, Asansol Bardhaman, my lord.
Where is the state judiciary? District judiciary.
My lord, Bardhaman,
High
my
Court administration is party
No, no,
lord. No, my
to serve and come back.
Judgeship of Paschim Bardhaman. And this will not. May I cut short the matter, my lord? My lord, he was working under the judgeship of District Judge Paschim Bardhaman. My lord, he was suspended because, my lord, he was arrested under 302 and other sections. Now, my lord, he is acquitted. My lord will find. Please do not interject. The order of acquittal at page 70. At page 71. Now, my lord, page 70, my lord, he had thereafter, my lord, prayed for reinstatement. Page 72, my lord, will find
1 second. Acquittal is page
71, my lord, the ordering portion.
then.
My lord, thereafter, my lord, he prays for reinstatement. Page 72, my lord, will find the order of reinstatement.
Oh, he has been reinstated.
Yes, my lord. It's past 72, my lord, the order starts, which is for reinstatement, my lord. Passed by the district judge, Paschim Bardhaman. My lord, now his prayer is, the lordship will kindly see the prayers. His prayer is, my lord, release page 13, my lord. Release of salary for which, my lord, he was put under suspension. Page 13, my lord, will kindly see.
arrear salary, my lord.
Now, my lord, I find a representation, page 74, pending before the authority. Let it be decided, my lord, subject to what my learned friend said.
And what happened against the order of acquittal? Now, my lord, an appeal has been preferred. That appeal is sub judice before this honorable court.
So let that be decided.
Unless and
Of course, adjourn, sign it down.
this is the my lord, appeal number, my lord, CRA 19.
My lord, I am not on that, my lord. That is pending, my lord, but I am acquitted, my lord, since that fate has not been come from that appeal, my lord. It is pending, my lord. My lord, my only, my lord, prayer is, my lord, to consider the representation, my lord. My lord,
But
yes, my lord. salary,
district
my
judge
lord.
cannot sit over the my lord, the pending appeal.
Why do you submit? He is making a submission.
My lord, and your lordship,
I'm
there is a judgment of your lordship, my lord, Subhash Mahato, my lord, if your lordship.
What
But
did I hear?
that is for the that was for the pension, my lord. That criminal case has no nexus, my lord. That was for the pension, my lord. But here is, my lord,
302 charge, appeal pending. I will allow.
no, my lord. I'm not on that, my lord.
Ashu.
And only one submission can I make. I had a talk with the learned district judge. After the appeal decided, whatever it may be, he may apply. We will consider in
My
accordance
lord,
with.
my lord.
Or
So
after
I am disposing it off.
My lord, dispose it off.
I am granting you liberty. After the appeal arrives at its finality, you will be at liberty to apply.
My lord.
and if ultimately,
that-
if ultimately something happened,
But whatever. Ashu. Mr. Nikhil Gupta.
Kumar Gupta.
Nikhil Kumar.
Kumar Gupta.
এখনো কুমার আছিস এখনো কুমার তাহলে
Mr. Nikhil Kumar Gupta, learned advocate, appears for the petitioner. Mr. Nilotpal Chatterjee, learned counsel, appears for the state.
My lord.
Any designation you have?
Junior government advocate, my lord.
Learned state counsel appears for the state. Mr. Devjit Mukherjee, learned counsel, appears for respondent numbers
2 and 3. 2 and 3.
2 and 3. High Court administration is party.
No, my lord.
District judge and chief judicial magistrate.
The petitioner was an employee under the relevant district judiciary. Arising out of a proceeding against the petitioner inter alia under section 302 of Indian Penal Code. The petitioner has suffered custody. First. Consequently, the petitioner was suspended. Subsequently, by a judgment and order dated May 11, 2023, petitioner naam ki Polash
Kumar Kormokar.
Polash Kormokar. By judgment and order dated such and such, passed by the jurisdictional criminal court, the petitioner was acquitted. As the petitioner was not found guilty to the alleged offences. The order of acquittal is annexure. আচ্ছা দরকার নেই, আমি তো খারিজ করে দিচ্ছি। Today, when the matter has been taken up for writ petition has been taken up for consideration, দেখি কাগজ দেখি এই তো। Mr. Devjit Mukherjee, Learned Counsel for the District Judiciary, submits that an appeal has been preferred from the said order of acquittal and is pending before this court after being registered CRA, all bold, cap, CRA within bracket DB 196 of 2023, right?
When the petition has been taken up for consideration, Mr. Devjit Mukherjee and counsel for submits that an appeal has been prepared from the said order of acquittal and is pending before the for this after being registered CRA.
After being registered as bold code paragraph. In view of the above, comma, this court is of the view that no further step can be taken in this writ petition at this stage. Paragraph. After the said pending criminal appeal is finally decided, comma, the petitioner shall be at liberty. Decided, comma, depending upon its fate, the petitioner shall be at liberty to apply and lodge his claim before the jurisdictional authority in accordance with law. Poster. However, it is expected that in the event the petitioner is finally acquitted, the district judiciary shall consider the claim of the petitioner expeditiously, but in accordance with law.
Only thing, what happened, I found from the record that when he applied, we have to send before the principal secretary, judicial department. They opined us that is not possible. Therefore, your lordship, we are not the disbursing authority. We have to send before the principal.
The district, ki bollam? Comma, depending upon its fate, comma. Full stop. The jurisdictional authorities, ডিস্ট্রিক্ট কথাটা কেটে দিন, the jurisdictional authorities shall
consider the claim of the petitioner expeditiously, but in accordance with law.
Without any delay.
Since so no affidavit has been filed, my lord, that's
Paragraph. Since no affidavit has been called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. With the above observations and directions, this writ petition WPA 3410 of 2025 stands disposed of, comma, without any order as to cause. Written number ta bold, direction kotata kete din with the above observations.
I am led by Mr. Learned Government Peter. May I give the appearance?
তো ওখানে উপরে কি বলেছি ওই নীলোৎপল চ্যাটার্জি led by Mr.
Learned Government Peter, my lord. Amitabh Broto Roy. Amitabh Broto Roy, my lord.
ও গভর্নমেন্ট লিডার।
Government Peter.
আচ্ছা কি বললাম মিস্টার led by Mr. Amitabh Broto Roy, learned government leader.
Deeply obliged, my lord.
Grateful, my lord.
He has come to court.
Yes, yes.
I am for the respondent number 6, my lord.
South Bengal State Transport Corporation.
এই এটা নিয়ে নিন affidavit of service.
I am led by Mr. Oyon Banerjee. I am led by Mr. Oyon Banerjee in this matter.
Got the previous, Lordship, the petitioner before your lordship. She is the sister of an employee of the South South Bengal Transport Corporation. Lordship, he has expired. Before, Lordship, he was previously married. His wife deserted the house with his 2 children about.
Has he been formally divorced?
No. But what he did, your lordship, he changed the nominee. Previously, the nominee was in favor of his wife. Thereafter, when his wife deserted him, he took all efforts to trace her, including police investigation, your lordship. He also published it in a Doordarshan and made general publication. But he could not trace her. Thereafter, your lordship, because of his ill health, he was staying with his sister. And while he was staying with his sister, he thereafter changed the nomination in favor of his sister. Lordship, she's not his own sister, she's his cognate sister. So he changed the nomination in favor of his sister.
He's impleaded.
She is a petitioner. The sister is the petitioner before your lordship.
No. But the wife?
Lordship, all efforts, also the respondents sent notices to the wife, no response.
She is impleaded?
No, your lordship. Because we do not have her address, your lordship. Her address that we have is the address of her husband.
After all, madam, the moment
she's impleaded, your lordship. But your lordship, lordship, I'm sorry, my
proper address is number 7.
Yes.
Proma is the wife.
Lordship.
And certain things, my lord, let my learned.
The lordship, what has happened is that when he changed the nominee, in the nominee form, instead of sister, by mistake, it has gone down as wife in changing the nominee. But she's not his wife, she is his sister. So, lordship, that mistake, whether it is a mistake by the department or whether it is the deceased employee's mistake, is something we do not know. Lordship, we were asked to file an affidavit.
The original employee has died.
Lordship.
So, sister applies as a beneficiary.
Lordship, she has applied as a nominee.
No. Here as the beneficiary.
Lordship, she's a nominee.
Nominee means she will merely receive.
Lordship, there are 2 types of nominees. Lordship, after the 2015 amendment, there are 2 types of nominees. There are the beneficiary nominees, there are the collector nominees. So, Lordship, the question of beneficiary nominees are those who are treated as a family. And collector beneficiaries are those who are collecting the amount and they will disburse it to the legal heirs.
Basically an agent.
So, Lordship, in this case, The wife was the family. He has removed the wife's name and he has put her name. Albeit, your lordship, under
One
the
second. This removal is not disputed.
no, your lordship.
As per our record, there is no removal.
Lordship, I
Your
have
record means
The South Bengal State Transport
oh,
Corporation.
there is no record.
lordship. The
What
employees.
about
My lord, so for the
you are for
state, I'm for the state.
state really doesn't matter at this stage. State is merely a disbursing authority at best,
Yes, but
provider of fund.
I just need to draw your lordship's attention.
No, I will hear you. I will hear you. But you are the principal employer. So it's your liability, its obligation, whatever. If crystallizes in law. So you say, according to your books and records, there is no nomination, no change of nomination.
And the PPO, my lord, in page 42, the Aparna Das name was they.
So very well. Do one thing. Do one thing.
Lordship will kindly come to page 42 and 43 of the report.
Madam, let me be very candid.
Lordship.
I must call for an affidavit
Lordship.
in the form of report or whatever nomenclature with all documents from the employer as well as from the state. Let me be very candid. If I hold against you, then there will be no requirement of service of notice on 7. If I think no, presence of 7 is required, at least a notice in the eye of law is required, then I shall take steps by publication or whatever I will see.
That's fair enough, your lordship.
Otherwise, unnecessary, you will have to bear the expense. If I finally hold that writ petition has to go, then no utility in serving and taking effort after 7. Ashok.
So far, lordship, the Provident Fund authorities are concerned. We have acted as per the instructions supplied or the documents supplied by the employer.
You also, you are a party to this.
Yes.
Lordship.
File your affidavit. How does it matter?
Fine.
Ashok. Madam, service. Affidavit of
Your
service.
lordship, I have it.
Affidavit of service filed in court today is taken on record. M.S. Shama Mukherjee, learned senior advocate, appears for the petitioner. M.S.
Kebusri Dhamali. Kebusri Dhamali.
Learned advocate led by Mr. Owen Banerjee, learned advocate, appears for the state.
For the South Bengal State Transport Corporation.
For SBSTC. Stroke, respondent number.
This one number 3, 4, and 5.
3, 4, and 5. Mr.
Rajiv Ray for
Rajiv Dey, learned advocate, appears for the respondent number
6.
6. Stroke, Provident Fund Authority. Mr. Shubhra Prakash Lahiri, learned advocate, appears for
The state, respondent number 1 and 2.
respondent number 1 and 2. Stroke, state.
Myself, Rajiv Ray, RAY.
Rajiv Ray, RAY. Related to the famous Ray.
My lord, not Ray.
You will know. Full stop. The moment the expression comes Ray,
Lordship.
the Bengali personality, that
Lordship.
towering personality comes. You will know. Hold on, likhun. The writ petitioner claims to be the sister of a retired
and deceased.
Retired employee of SBSTC. Namely,
Dipankar Das.
Dipankar
Das.
Das, bold korben, since deceased. The said employee died on
the 27th of November 2022.
Sorry?
27th November 2022.
November 27, 2022. Take the microphone. Because the acoustic is a bit problematic this side. November 27, 2022. The respondent number 7 claims to be the wife of the
Deceased.
deceased employee. First.
But she doesn't claim, Your Lordship, she's alleged.
No. The respondent number 7 to be the alleged wife of the deceased employee. First. Paragraph. Learned Senior Counsel M.S. Mukherjee submits that the respondent number 7 had deserted the employee long back and thereafter could not be traced out despite repeated efforts alleged to have been taken by the employee concerned.
Had two son also.
I said
First.
the two sons.
Where is the son?
Lordship, we do not know. They left in August
It
2015.
is also submitted that out of the said wedlock, alleged wedlock of the employee and respondent number 7,
They're not made party. The party one.
It's not alleged. It's not alleged, my lord. The employee himself mentioned that Promadas is
Acha.
his wife, and they have to.
Out of the wedlock between the employee and respondent number 7, a son is there.
Two sons,
Two
Lordship.
sons are there, namely
Shubhankar Das and
Shubhankar Das and
Rupankar Das.
Rupankar Das. Full stop. Full stop. These persons are also named in the service record. No. You said that he nominated?
No, Lordship. He nominated only his wife.
Promadas' wife.
Wife.
Son is the name of the son is mentioned in page number 29. That is the letter of the deceased employee.
Basic facts দরকার affidavit হবে তত দরকার নেই কি বললাম কেটে দিন আসুন submitted that the two sons are there. Full stop. ছেড়ে দিন paragraph. At a later stage of employment, the deceased employee nominated the petitioner, being his sister, in respect of his employment benefits. First. The petitioner now seeks a correction in the service record where it is shown allegedly where the petitioner has been shown as the alleged wife, but not the sister. In view of such dispute, the petitioner has not received the employment benefits of his brother, the deceased employee. Full stop. Paragraph. What is your submission, madam? Miss M.S.
Devasri Dhamali.
Devasri Dhamali, learned advocate appearing for SBSTC, submits that
my lord, we have given a hearing to them also, and thereafter we have written to the Commissioner of Kolkata Municipal Corporation regarding the airship, but we have not yet received any response from the Kolkata Municipal Corporation, and we don't have any paper that she is only the heirs to whom we can disburse our benefit.
and appearing for the SPSTC submits that
the employer has granted an opportunity of hearing to the petitioner. And thereafter, in writing, inform the petitioner that the employer is not.
Inform not the petitioner, the Kolkata Municipal Corporation, they have annexed
No, you have not informed him. Huh?
regarding.
What you have arrived at, your
No,
decision.
They have only called her for an informal,
We have given a hearing to them and
informal hearing, Your
along
Lordship.
with all necessary documents, but no headship.
was granted an
The employer has already sat with the petitioner on the issue. And thereafter, the employee has asked for the details of the legal heirs, but no conclusive material was produced before the employer. Full stop.
Through the KMC, Lordship, Calcutta Municipal Corporation.
That is pending, that they have done.
That is pending.
That they will disclose through affidavits. How does it matter?
Lordship, I have disclosed it in my petition.
He has annexed.
Acha, full stop. Necessary application has also been submitted by the employer before the Kolkata Municipal Corporation to disclose the particulars of legal heirs of the employee. Full stop. The same is pending. You have made corporation a party?
No, Your Lordship. Because as far as I am concerned, Your Lordship, the legal aid certificate is not required in law.
Full stop. Paragraph. What is your submission state? That's right. The paragraph, the Provident Fund Authority submits that they shall act only on the basis of the instruction they will receive from the employer SBSTC. Paragraph. Considering the above, comma, it appears to this court that there is no scope for any interim order. First step. Who shall file?
Managing Director.
There is no scope for interim order. Full stop.
Respond number 4.
Paragraph.
Or 5.
The respondents shall file reports in the form of affidavit with all the supportive materials in support of their stand on or before
3 weeks, my lord.
2 weeks, Your Lordship.
3 weeks, my lord. As your lordship.
A very simple matter, Your Lordship. 3 weeks.
As your lordship.
आदमी को 15
So I have to take instruction of the regional office of the PF in this matter, Lordship, is at Durgapur, Lordship. If your Lordship, so please.
August 5.
August.
August 5, 2025.
August 5. अच्छा.
Full stop. Copy shall be served upon the landed advocate on record for the petitioner. Paragraph. The petitioner shall be at liberty to file its exception thereto in the form of affidavit. Give me on or before
Lordship will give me a week's time.
August 19, 2025. The writ petition shall appear under the heading motion service on August 21, 2025.
Lordship.
Paragraph. Likhun. Depending upon the stand to be taken by SBSTC in its report, this court shall decide whether any notice is required to be served upon respondent number 7 or not.
Great. Great.
Oh,
Your Lordship.
pleasure.
Thank you. I'm coming within 10 minutes. একটা ছোট্ট কারেকশন আছে জাজমেন্টে আমি দিদিকে বলে দিয়েছি
In pursuance of your lordship's order, my lord, I am filing this supplementary affidavit, my lord, leave granted by your lordship's liberty. My lord, this is a petition, my lord, where the petitioners are the, my lord, retired NVA personnel, my lord, without having any, my lord, pensionary benefit or retiral benefit.
You've served.
There is, yes, there is no provision of such a retiral benefit. After serving 30 years, my lord, only drawing at the time of retirement 3,000 rupees. So the government has accorded a benefit of one-time ex-gratia payment, 50,000 rupees, my lord, that I have annexed, my lord, in annexure P6, page 41.
Show me your appointment letter, sir.
Yes, appointment letter, my lord.
That is not page 17 onwards, that is the their card, ID card.
My lord,
Appointment letter, engagement letter.
next,
Legible, that is page number 18. That-
page 17 onwards.
17 is not the appointment letter.
That is ID.
Not required. Show me the appointment letter.
No. Page 17, my lord, onwards.
17 is not the appointment letter, sir.
Yes.
Right. চলছে তো। Show me the appointment letter.
Of the ID card is there. That they are working.
Sir, I want to see the appointment
No.
terms and conditions.
Yes,
That
my,
page number 18, that is also not legible. So old and dark.
These are not appointment letters.
After the page number 21.
I must know the terms of employment.
no,
Employment
terms of employment, my lord, under the NVA Act, my lord knows that the terms of employment is this, my lord, to serve, my lord, the force after getting, my lord, the meager amount of rupees, my lord, 3,000.
discharge certificate is there. That was from the
No, I don't disagree that you worked without any complaint. I don't disagree to that.
Yes.
But how do I interfere? It's a policy
Right.
decision.
that is page
Discharge certificate
number,
আছে?
kindly see page number, paragraph 2 and 3 of the supplementary affidavit. My lordship has ample power to relax. Since Lord, I have stated in paragraph 16 and 17 to the.
I cannot, sir. I cannot.
No,
How
Lord.
can I intervene with the service condition?
No,
It's a policy decision of the state.
But,
No.
but,
my lord, this is a policy decision of the state. That is why, my lord, we have come up before your lordship, my lord. This
I can
policy
intervene.
decision, my lord, can be invoked, my lord, by sitting, my lord, in a read jurisdiction by your lordships, my lord, to get the benefit, my lord. Only the relaxed to cut up dates, my lord. My lord, I have number one, petitioner number 1 retired, my lord, 4th January 2008. And the petition number 2 retired on 19th October 2007. Paragraph 2 of the supplementary affidavit. My lord, only shortfall of, my lord, the petitioner number 1, only, my lord, 7 months. And the second petitioner, my lord, that is only 10 months, 10 days. So, my lord, only to relax that, my lord, only to relax the cut-up dates, my lord, we have come up before your lordships, giving this mercy petition before your lordships, my lord. It is up to your lordships, my lord, in every stage, my lord, where the shortfall there, the writ court, my lord, by invoking the jurisdiction, and, my lord, sitting in a jurisdiction, invoke the, my lord, power to relax the cut-up dates, my lord. And that is confined to the petitioners. So, my lord, here they have served 30 years, my lord, without having any, only for few months, my lord, they are losing the benefit of ex gratia payment, my lord. Only few months.
Why few months you are saying?
Yes.
From the date of retirement.
From the date of retirement.
Page 42.
From the date
Page.
of retirement.
Page 41.
41 is the notification. Page 42 is the relevant date.
42. 42 is irrelevant.
Point number 3 towards the bottom.
This will come into effect from 1st September 2008.
Yes.
And how many petitioners are there?
2.
Yes.
2. They have retired on?
One first petitioner
4th
in
January 2008.
19th October 2007.
That is second petitioner.
Second petitioner and the first petitioner on 4th of January 2008.
8. And the effect was given 1st of September 2008 of the GO. Lord, GO has been issued not on the base.
One has retired on 4th January 2008.
8.
That is first petition.
First
Acha.
petition.
The other one,
19th October
what do you say?
2007.
This is a policy which has been taken, a cutoff date has been fixed. Somewhere the government thought it fit to start from. I do not know
No,
at
Lord,
this
yes,
juncture.
Lord, I will only.
Primarily, this is of 2008. They have retired long back.
Facts, nobody is disputing.
Now, whether the government will at all relax that part, and even if we extend, if your lordship extends the mercy to how many petitioners or to whom, there may be several others who may come within the zone. If you
Lord, yeah, a minute. Yeah.
No, that,
Here,
that
my
is-
lord.
I will say that this order will not be treated as precedents.
Yes.
If your lordship is extending mercy, my lord, I have nothing to say.
My learned friend is very fair enough, Lord, not to, Lord, take any hurdle on your lordship's, Lord.
Let it be
Mercy,
sent to
my
the
lord.
appropriate
On your
authority
lordship's
on
mercy.
a sympathetic ground.
Yes.
Very well, I am sending before the authority to consider sympathetically.
They will not, my lord.
Lord,
Probably they will not.
unless,
see,
Lord,
let
there
me
is a mandatory, Lord, order from your lordship's, Lord.
Difficulties elsewhere.
Lord,
Difficulties elsewhere. Difficulty is not
Case
for
of
these two.
education matter, my lord, where the 10 years is required for, my lord,
That's a different thing.
pension benefit, your
But
lordship.
this is, I tell you why, the difficulty is elsewhere. This is not restricted for the two petitioners. The moment this order will pass, 100 will come.
Here,
The
no,
difficulty is there, not for these two petitioners.
no, that's right. Your lordship is perfectly right. There I am not. I am only, my lord, joining one issue, my lord. One, not in the precedent. My lord, that is that this GO has been issued not on the basis of any statute, not on the basis of any act.
No, not required.
It has,
So
my
long-
lord,
so long-
only the discretion of the government. Government has taken a
Absolutely,
policy.
it is a policy
my-
decision. There is no wrong on the part of the government to
No.
fix a cutoff date. There is no
Yes.
wrong. No wrong.
No,
The-
that we are not disputing, my lord,
Absolutely,
not
absolutely,
disputing that.
Absolutely. But only thing is that the moment it will be done, it will 100 people will come. That's the difficulty. Difficulty is there.
Only
No,
one
Lord,
more thing. This
if
is
anybody comes to your lordship's, Lord, it is
the-
up to your lordship's will, whether
requirements
your lordship's will.
no pay. And they were permanently demobilized. It should not be
Yes,
coming within the terms of retirement. It is permanent demobilization.
demobilize. That is the term of the force. That is the term of the force, demobilized.
Difficulty is there. Not for these two petitioners, may not be. But 100 will come.
Lord, as it not based on any statute, so Lord, the GO can be altered or modified, Lord.
I'm not on that. Again, I'm
Yes.
saying.
If it is sent, page of 40, they have replied on the basis.
If it is done for two,
Dealing with
if it is done for two, then 200 will come tomorrow. Then what will happen?
telling that it is sent for consideration.
That is the difficulty.
That is plain of 40, their reply. No, it cannot.
If it is done for 2, then tomorrow 200 will come. That is the difficulty. For 2, they also don't mind.
See that in that moment, it can be
Right.
under when.
But where the shortfall is so narrow.
No, it's not really narrow. 4th of January 2008, which is 10 months.
10 months.
9 months.
9 months.
9 months.
Another one is 19th October,
No.
1 year.
First one is 7 months.
7 months.
And second one is 10 months.
10 months.
10 months.
I
10
don't mind, but the thing is what I'm thinking, then I will not be able to, the court will not be able to control. There is the problem. If it can be done for 2, then immediately 200 will come. That's the problem. Problem is there. Let us be practical about it. Let us be practical about it.
If they come and get center from your losses, Lord, to get some bigger amount, Lord, as a ecclesia, 50,000. They are the citizen of all, Lord, country.
No. Citizen, fine. Citizen, fine. Citizen is fine. Had it been an illegal act, I could have done it immediately by setting it aside. But the moment discretion will be used, the moment it will be used for 2, tomorrow 200 writ petition will be filed. That's the problem. Trouble is there.
If it comes, Lord, then your losses will decide that, Lord. And Lord, the government will be bound, Lord, to relax the aid.
No. I cannot force something upon the state where there is no illegality. Where there is no illegality, no arbitrariness. It is not there. They even don't mind for the 2. For these 2, they don't mind. But if I pass an order, then tomorrow it will be 200. That's the problem.
Maybe 2000. Maybe 2000.
Answer. Giving beside their answer, your Lord says directed. The annexures which we have produced, Lord, that leaving beside their answers or their Lord, the orders, Lord, they
Sir,
they will take decision.
Let me not dismiss the writ petition. I am sending it before them. They shall use their discretion. But sir, I cannot pass any order, because the moment I will pass the order, tomorrow there will be 200 writ petition.
Only rider may be given, my lord, rider may be given not to take up the answer, the annexure, the rejection annexure.
Very well. Afresh.
Reconsider.
Leaving aside that one.
Afresh.
This decision, Lord, whether it can be extended or Lord can be given. Yes. Lord, kindly do
Let me pass the order as cryptic as possible. This type of order.
Supplementary kept on record.
Both the petitioners actually could. What is your name, sir?
Monoranjan Jana.
Asim Banerjee and
Mr.
Monoranjan Jana.
Learned advocate, and Mr. Monoranjan Jana, learned advocate, appears for the petitioners. Mr. Dipanjan Dotto, learned senior government advocate, with Mr. Shayan Dotto, learned advocate, appears for the state. The scope of the writ petition is very little.
My learned friend is very fair enough, Lord.
Both the petitioners were engaged on contractual basis for the post of
NVF,
West
my
Bengal
lord,
National Volunteer Force.
member of the NVF, National Volunteer Force, West Bengal National Volunteer Force.
as members of National Volunteer
Force,
West Bengal.
West Bengal National.
West Bengal National Volunteer Force.
West Bengal National Volunteer Force. সবকটার প্রথম অধ্যক্ষর বোল্ড করবেন, পুরোটা বোল্ড, পোস্ট, POST. Paragraph. The employment of the petitioners of the first petitioner was demobilized on January 4, 2008, and that of the second petitioner was on at that and of the second petitioner was on October 19, 2007.
Permanently demobilized.
Demobilized.
Demobilized permanent.
Permanent.
আচ্ছা কি বললাম পড়ুন। Was permanently demobilized
At
on
the age of
bolt
60 years.
on bolt করুন
At
on-
the age of
on-
60 years.
on January 4, 2008, and of the second petitioner on October 19, 2007, দুটো date bold, upon attaining 60 years of their age. Poster. Paragraph. Referring to a policy decision dated September 15, 2008, Annexure P6 at page 41, it is submitted that a cutoff date was fixed, being bold, September 1, 2008. For granting ex gratia,
One time.
One time it is.
one-time ex gratia. Paragraph. Since the first petitioner was permanently demobilized before about
7 months, 26 days.
before about 7 months, little more than 7 months,
7 months and 10 months.
and the second petitioner was permanently demobilized
10 months.
little more than 10 months before the said cutoff date of September 1, 2008, they became ineligible to receive the said benefit of ex gratia. Paragraph. The petitioners mercifully prays if the claim or if the prayers of the petitioner can be considered by the authority. কি বললাম পড়ুন তো একটু আগের থেকে পড়ুন
কিছু বলবেন
প্রেম কথাটা কোথাও দেবেন রে
এখানটাতে যদি তাহলে একটা গভর্নমেন্ট করতে পারে not taking into account
sympathetically will consider.
The rejection is by the state commandant.
Respondent number
2.
The respondent number 2 এবার লিখুন the petitioners shall serve a copy of this writ petition along with a copy of today's order upon the respondent number 2. Forthwith. Full stop. The respondent number 2 then shall consider the prayers of the petitioner sympathetically without being influenced by any previous decision, if taken already, if taken already, কি বললো? Shall consider the prayers of the petitioner if taken already. একবার পড়ুন। Afresh.
Yes. Afresh, my lord.
Without being influenced by any previous decision, if taken already.
If taken already. By exercising their discretion judiciously. Paragraph. However, it is made clear that this order shall not create any right or equity in favor of the petitioners. Paragraph, it is made clear that this court has not made any opinion on the merits of the claims, of the merits of the prayers made on behalf of the petitioners in the writ petition. Made by the petitioners in the writ petition. Paragraph. The decision shall be taken by the respondent number 2 and shall be communicated to the petitioners positively within a period of 6 weeks from the date of communication of this order. Full stop. Paragraph. It is further made clear that this order shall not be treated as a precedence.
Yes.
This order shall not be treated as a precedence.
Leaving aside. My lord, the earlier decision may be leaving aside, my lord, to take decision.
No.
The earlier rejection order by the state government, page 40.
I have said whatever I have to say, I have said. I will not. I will not set that aside. Sorry. কি বললাম? With the above observation, this writ petition bold WPA 5777 of 2025.
But preferably not to give effect of page 40 order.
Without any order. So, তার আগে একটা paragraph, since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents.
Much obliged.
আচ্ছা, একটা দেখুন উপরে supplementary affidavit filed in court today on behalf of the petitioner is taken on record. Full stop. Copy has been served upon the state.
I am grateful to your lordship. Your lordship is so kind enough, Lord, to give this.
I would have mandatorily directed, but immediately 2000 petition will come tomorrow.
Yes. Pandora box will be opened, my lord.
Then I will be in difficulty by I cannot take up the other matters.
Yes. Lord, the government will think, my lord, to extend the time after your lordship's order, my lord.
Chalo, next.
This order.
There will be no end of it. You are saying it will be extended from 1st January. And others will say 1st January, March 2 years before. There is no wrong in the policy decision of the state.
I am grateful to your lordship.
Yellow.
I appear for the response.
In this matter, I am claiming monthly monetary cash benefits. I am admittedly the married daughter. My prayer for MMCC has been rejected by the respondent authorities. Before that, I have, after death of the demised employee, I have prayed for compassionate appointment of my husband and the son-in-law of the demised employee. That prayer has been rejected. And thereafter, I made an application for MMCC for me. So that prayer also has been rejected by them. So I have challenged that. On the ground, on twofold grounds. On the first, the ground is that.
Have you brought my judgments? One is Bauri,
my
Bauri, the other one is the last I delivered in Mr. Partha Ghosh's matter. Where I have rejected the prayer for compassionate appointment, but I granted monetary benefit.
Those cases were different, Mala. This was not, those were not married daughter's case. This is a married daughter.
Married daughter?
Yes.
Show me that married daughter is entitled first.
Let him argue.
The relative definition, dependent definition.
There is a judgment of this honorable court. And first, I will show the scheme.
First, you show me when there is a specific policy, no judgment is required unless the judgment is on that particular policy.
Judgment is on that particular policy.
So show me that married daughter is entitled.
Yes, ma'am.
Show me the clause first.
Yes.
বাসুবাবু ওইখানে আরেকটা লিখে দিন তো ওই যেখানে লিখেছি না প্রিসিডেন্স কি বললাম পড়ুন it is further made clear that this order as well as the decision of the authority to be taken pursuant to the direction of this court shall not be treated as precedents. এক কপালে থাকলে পেয়ে গেলে পেয়ে গেল No, I told that practical difficulty. Had this been 2, yes. The moment these 2 will get, tomorrow 2000 writ petition will come. Absolutely. Show me.
As 9.5.0 is the employment monetary compensation to female dependent.
Show me that the married daughter is entitled.
Yes, married daughter has been excluded. Admittedly, excluded. I am not denying that.
Which NCW are you citing?
NCW 6.
Yes.
Because that is the relevant NCW. After that, status quo.
So if it is like excluded in a specific scheme,
yes,
how can I alter the scheme and rewrite it by including?
There is a judgment of this honorable court. 2023 SCC online Cal 3744.
Dipali.
By Justice Shekhar sir.
2023?
2023 SCC online Cal 3744. If your lordship directly comes to paragraph 13.
So first you show me that this is on this scheme.
Yes, paragraph 13.
First you show me from the fact that this is the scheme.
Yes, issue has been framed. If your issue has been framed,
show me.
Paragraph 13.
30.
13, 1-3.
No appeal carried out?
And I have not found any. They could apprise your lordship.
Paragraph?
13.
13.
1-3. Page 17.
Yes.
Yes, my lord. Issue 2. Whether the distinction between married and unmarried daughter as per clause 9.3.3 of NCWA 6 is ultra vires and is in violation of Article 14 and 15 of the Constitution of India. If your lordship sees thereafter, every judgment has been considered. Putul Ravi Das has been considered. Purnima Das has been considered. And thereafter, my lord's conclusion, your lordship will find paragraph 20.
But the moment, first you tell me, the moment married and unmarried will be equated, married equal to unmarried, will the definition of dependent not be changed?
If the definition is in violation of Constitution,
Why constitutional violation? That's why I'm asking.
even it, your lordship is indicating that this is an agreement. Your lordship is indicating that this is an agreement.
No. That comes later. I will say married daughter, unmarried daughter. Hell and heaven difference between the status. Correct. A married daughter is supposed to be first glance, should not be dependent on the father. On the father. She may be dependent on her husband, but not on the father. So how can a married daughter claim the benefit on account of the father, her father, and it says that it is constitutional violation?
Dependent employee is the mother of the malord. Dependent employee, demised employee is the mother of the malord petitioner.
Father, mother.
In any event, if the court deprecates this practice of excluding married daughter, and
this is single bench. This is coordinate.
And this single bench judgment has been pronounced, my lord, on the basis of the judgment of full bench of Putul Ravi Das.
Putul Ravi Das was different. Putul Das was that this scheme is mandatory. My Bauri is on Putul Ravi. Scheme is mandatory. It is the obligation of the employer to make known the beneficiary of this scheme. Even if a beneficiary does not know about it, does not apply for it, it is the obligation of the employer to extend that facility. And that's Putul Ravi Das. It's not on constitutionality of married or unmarried.
Full bench decision of Purnima Das is also there. And on the full bench of Purnima Das's judgment and another.
Purnima Das.
May I add only one thing?
Another.
Not only whatever your lordship was saying, Putul Ravi Das was deciding a point whether a divorced daughter is to be included.
I know that.
As an unmarried daughter.
Married, yes.
And on the basis of Purnima Das, where it was held that married daughter should not be excluded. On that basis of the judgment, a decision of
Purnima Das
is on another scheme. That is why on the basis of that judgment.
Sir, let us be very clear on this. If one particular scheme is there, I will not look at the other scheme.
Very well, that is why, I am showing your lordship the judgment of.
That's the law.
Yes, my lord. Judgment of Jharkhand High Court. This is division bench, and just by the bench of Justice Aniruddha Bose, when he was Justice, he was the Chief Justice of the Jharkhand High Court. To 2018 SEC online. GHAR 98918.
9818. Have you costed? Costed.
Central Coalfields Limited versus Hemanti Devi.
Hemanti Devi.
Paragraph 3 onwards. Paragraph 2 onwards, because 9.3.0 is the malad. In malad is in question. Paragraph 7 is the malad conclusion.
As I said, married and not and dependent on her husband. Show me the scheme where the relevant scheme was considered.
Malad, paragraph 2.
9.3.0, paragraph 2.
Yes, malad. Same point, malad, has been raised. Paragraph 3.
Yes, show me Purnima Das.
Purnima Das, I'm not carrying out.
Very well. You file a report required, or you will argue on the point of law?
On the point, this, my lord, I think, my lord, it's on the point of law. It will save the honorable court's time also, my lord, filing report.
So come back on the day with all judgments.
My lord, the all judgments, my lord, whatever he has relied.
He will place Purnima Das.
Purnima Das. I will place two, three judgments, including Putul.
You bring all those judgments
I
and
am
you
ready with
take the citation of this.
I have given.
You have to deal with this.
No, that I know, my lord. I can deal with this right now.
Oh, tell me.
My lord, first approach is this, my lord, with the deepest of respect, my lord, in the Himanta Kumari, my lord, the Honorable High Court at Jharkhand, my lord, has proceeded, if your lordship says it, my lord, has proceeded on the basis as if the scheme is an unilateral scheme. It's not that, because it has not considered the Mohanlal Mahato's case, which was decided by the Honorable Supreme Court, declaring that it's a settlement. It's a settlement means it's a bipartite agreement. Parties settle, and once there is a settlement, as your lordship knows, that under the Industrial Dispute Act, both the employers and the employees are bound by that. No one can resign. And whatever is written in it is to be followed. Nothing more, nothing less. We have, our division bench has a decision with a more pragmatic approach that I will place before your lordship.
And that division bench has discarded this contention,
Yes.
unmarried daughters.
Yes.
Bring those.
Because
Interesting.
Interesting. Because it says, our division bench says that whatever is written, you cannot resign from that.
অভিভাবক একটা ফাইল করুন, এটা সবকটাই লিখুন পিটিশনার আজকের ডেট।
And this single bench judgment, what he has placed, my lord, it was filed ultimately.
Single bench I have seen. Single bench I have ways and means to come out of
Ultimately,
it.
writ petition dismissed. It has not declared that it is ultra virus. That cannot be.
Okay. And that there I have the observation I have read. I have ways and means.
And the
to come
division
out of
bench,
it.
our division bench order is not considered in the single bench. I will bring
The
it.
writ petition has been dismissed on the ground that the
What is the ground?
they are not dependent upon the employee.
All right.
Here also, that ground is there.
If that be the point, then how this point will be decided?
The issue has been framed.
Maybe
on that ground,
can the issue travel beyond the claim?
In writ petitions, his lordship, my lord, has framed certain issues.
Sir, if that issue does not arise from the writ petition, then it will be binding.
This is the second round. This is the second round of litigation. First round of litigation, her husband's application for appointment was rejected. Means the petitioner's husband, my lord, was rejected on the ground that he was not dependent.
No.
I will show. What? No. I will show it from the
Let him show.
order. I will show it from the
And
order.
there is no challenge to that.
I don't. It's unchallenged, my lord. It's unchallenged. I will show.
Okay.
I will deal with that.
The short question to be decided. আচ্ছা তার আগে লিখুন Mr. Angshunath Chakraborty, learned advocate, appears for the petitioner. Mr. Manik Das, learned advocate, appears for the relevant coal company.
All the respondents are here.
Respondents, coal companies, / respondents. The short question needs to be decided is whether the expression married daughter can be read into clause
9.3.3
3.0 of the
9.3.3
9.3.3 of the
NCWA 6
NC National
Coal
Wages Agreement
6
dash Roman 6, a national in cap coal C cap wages W cap agreement A cap পুরোটা রোমান 6 এটা পুরোটা বোল্ড প্রত্যেকটা ওই শুরুটা হচ্ছে ক্যাপিটাল লেটার ব্র্যাকেটে NCWA ফর শর্ট NCWA dash Roman 6 কি বললো Slash बोलेंगे dash for granting compassionate appointment
MMCC
and or
MMCC
MMCC benefit.
only MMCC my lord.
Here, my lord, no compassion employment.
আচ্ছা compassionate টা কেটে দিন for granting MMCC benefit. এই MMCC কথাটাও bold benefit. Full stop. Learned counsel for the petitioner prays for some time to bring some judicial precedents on the issue. Paragraph for the ends of justice. Such accommodation is granted. Paragraph. The writ petition shall appear under the heading for orders. Argue on a Saturday. I tell you why. Second, we are open. So that I
have
can
no
hear it
problem.
out and finish it off.
Middle.
Right? On কি বললাম? For orders on August 2, 2025. We are open on that day.
Yes.
Come, argue another big matter I have fixed. I will decide that. I will also decide this, give dictation in court. Sure.
তাই তো শুনুন আমার ঠিক এইখান তো বললো এটা খোলা আছে করে দেবে করবো কি আছে
for me to mention a matter, my lord, not in your lordship's list, my lord. It's a 6 matter, my lord. My lord, what has happened here, my lord, certain employees had sought for a higher payoff scale, which the authorities, DVC authorities, refused. Against that, they came up in a writ petition, and an interim order was passed where, my lord, we were directed to make payment at the higher rate with the observation that we will be in a position to recover it. So no. So, my lord, what is now happening, my lord, there are judgments galore which says that once an employee retires, my lord, it is not possible to ask for refund or take back the money paid in excess. My lord, most of the petitioners.
No, but you're paying it under the court's order.
Pardon, my lord?
You're paying under the court's order.
My lord, even if it is under the court's order, my lord, there are certain observations, my lord, which would require, my lord. But kindly, it's an original said matter, my lord. If it
No, maybe, but hearing, it's very difficult.
let it appear in the list. Let
Two other benches are there, Mr. Ray, irrespective of classification hearing. Very difficult to accommodate hearing matters. And you are paying by virtue of the court's order.
But the court's order was
If that order, if the writ petition stands dismissed and that
then restitution will not apply. Restitution, my lord, under 151, 148, 144, my lord, it won't apply, my lord, because of orders of the Supreme Court in this basis, my lord.
Order was the Supreme Court, that is in Rafiq Ahmed.
Rafiq Ahmed, there are
Rafiq Mashi.
Rafiq Mashi.
Rafiq Mashi.
Rafiq Mashi will not apply. Rafiq Mashi is a demand from the employer and not in terms of court's order. Now, Rafiq Mashi is not in terms of court's order.
The demand
All right. Hearing matter. I cannot accommodate simply now. Sorry, sir.
No. May I have your lordship leave to mention one matter, my lord, upon notice to the other side, my lord. Your lordship was pleased to pass an order on 10th July in item number in CA number 63 of my lord, in the page 7, my lord, the direction has gone down little wrongly, my lord. My submission was to file the affidavit in oppositions because we do not file the affidavit in oppositions. It could not be made ready. A direction was.
You said you have filed. I remember.
No, my lord.
I asked.
My next persons was is the insurance company.
You have
They have
never prayed for extension. You had never prayed for extension.
my lord, my copy has my things has been affidavit in opposition has yet to be ready.
So you have never prayed extension. Then your prayer should have been there that I'm praying for extension. You have never prayed extension.
My lord, very
You
well,
have
my lord.
never prayed extension. Never.
My lord, your lordship.
Guys, remember, even if this has gone down wrongly, I say, though it was not, to my understanding, but you have never asked for extension.
My lord, it failed from your lordships that the same directions for 7th August, it would be here also.
Come up with your affidavit ready. You make your affidavit ready in the meantime. You file 2-page application.
Application.
I'll modify.
Lord, I am, terms of your lordship order, I have got all 3 affidavits in reply stamp.
Is this the matter appearing today?
No, your lordship had directed that as soon as it is stamped and
It is regularized.
file it here. So I am filing it.
Very well. Give it. Keep it in the record.
May these 3 affidavits in reply be accepted.
My lord, should I be?
Why you are filing? You keep it with you.
Yes, your
At the
lordship.
time of hearing, you do it.
My lord, should I be prepared this affidavit and come before your lordship for
Yes, prepare this affidavit. Come with 2-page application.
application? My lordship, as your lordship.
Yeah, because I still remember you have never asked for extension in any manner. No extension was asked for. No extension was asked for.
Yes, some
My lord.
still present.
Huh?
Might have some, your advocate on record.
No, no,
might have
not
missed
that.
those.
I myself.
He appeared. He appeared. Do
Appeared.
one thing very well. Prepare your affidavit, serve on her. You please accept it.
I'll accept.
Prepare your reply on the basis of that. When the matter shall be called on, you just remember me. I will modify this and I will take them.
I'm grateful.
Item number 1. May this direction of your lordship can go down in the court?
Not at all.
Or,
Not required.
I'm-
You accept it, you prepare your reply.
Yes,
So that matter will not be delayed on that day.
my lord.
I will accept that affidavit by modifying my order. Yes.
Item number 1, put application.
Well, I have the petition in this matter.
I appear for the respondents.
This is also another case of the monetary compensation. May I file my supplementary affidavit? Here, if your lordships kindly see the last order. Last order, my lord, this honorable court directed the authority to, my lord, take decision on the representation and to come back. And they have taken the decision, and I am filing, my lord, the supplementary affidavit annexing that decision. They have refused to pay the monetary compensation from the date of death. Now, fact is, my lord,
So you are challenging that reasoned decision.
Practically, I am praying for monetary compensation from the date of death. This is the, my lord, subject matter, my lord. Here, my lord, in 2017, husband died.
If you don't challenge that, then I will not be able to set aside.
In supplementary affidavit, I have challenged.
That cannot be done. That cannot be done.
There was a, my lord, direction.
There is no prayer for setting aside, nothing.
Because at that time, my lord, that reason order was not there.
Not there, now it has come, so you file it. If you wish to challenge it, you challenge it whole. His lordship has observed that he has not gone into the merit. So you take all grounds. You take all the grounds.
Well, kindly see, my lord, this.
I will not take up like that.
The supplementary affidavit I have, my lord.
Very well, but even if I am satisfied, I will not set aside the order.
Very well, my lord. Very well.
I will not be able to set aside. This order shall remain. Think about it.
Ultimately, my lord, if your lordship set aside this, my lord,
complication will arise. That will be on your burden, not the court burden of court.
Well, kindly see page 57.
Sir, if you regularize this matter, regularize it, file by a fresh writ petition. I don't mind. I will record that. This coordinate bench recorded that this was not gone in, merit was not gone into. I will also record I have not gone into the merit. All points are kept open for challenge.
Actually, I am, my lord, covered by your lordship's, my lord, judgment.
Very well. But I will record that. This is a new cause of action and I will not touch it.
But page 57, if your lordship kindly see, they have all same thing they have, my lord, stated.
Maybe. I will set aside if I am satisfied page 57, but not this one.
Very well, kindly see, my lord, page 57, my lord.
No, doesn't matter to me. Not required to be seen. If I am satisfied on merit, I will set aside that, but with an observation, I have not touched it.
Very well. Very well.
Then complication will arise. Think of that.
Well, kindly hear out, my lord.
Ashu. But I will record that this has not been challenged. It's merely a brought on record.
Very well, my lord.
Yes.
You have filed your affidavit?
No order for report or affidavit, ma'am. No order.
The last order dated January 21, 2025 speaks for itself. The said order shows, আচ্ছা তার আগে Mr. পার্থ ঘোষ, Learned Counsel appears for the petitioner. Mr.
Manik Das,
Manik Das, Learned Counsel appear for
the respondents.
respondents, stroke coal company, relevant coal company. তারপর হচ্ছে the last order, আচ্ছা যেখানে অসুবিধা হবে আপনি আমি থামিয়ে দেবেন, দিয়ে আমায় জিজ্ঞেস করবেন। The last order dated January 21, আমি এইভাবে লিখি, January 21, 2025 speaks for itself. Post. The said order also depicts that the coordinate bench has not gone into the merits of the case, but directed the respondent number 3, ECL to decide the claim made by the petitioner by its representation dated August 23, 2024. First paragraph. Pursuant to the said direction, ECL has passed a reasoned order dated February 17, 2025. First. Paragraph. Mr. Partho Ghosh, learned advocate appearing for the petitioner, prays for leave to file a supplementary affidavit to disclose the said subsequent reasoned order dated February 17, 2025. First. Paragraph. Such leave is granted. The supplementary affidavit filed in court today, disclosing the said reasoned order dated February 17, 2025, is taken on record. Copy has been served upon Mr. Manik Das. This court is of the view that the said reasoned order dated February 17, 2025 is a fresh cause of action and beyond the scope of this writ petition. Beyond the scope of this writ petition, as no prayer challenging the said reasoned order dated February 17, 2025 is available in the writ petition. Poster. Available in the writ petition, and rightly so. And rightly so, as the reasoned order is subsequent to the filing of the writ petition. Poster. Paragraph. Mr. Partho Ghosh, learned advocate, submits.
I am submitting that the prayer, suo motu, praying for molding of the prayer, because for the ends of justice matter is not complicated, very small matter, and for the ends of justice.
Sir, how I can mold this prayer? Then you amend the writ petition. Something must be there.
Suo motu is now, your lordship.
Everything suo motu.
Prayer can be molded, your lordship.
Prayer can be molded where?
Because my challenge and their reason order are the same.
So
there is
here your writ petition. What will happen will happen. I will not make any comment on this order. কি বললো?
Available in petition and as the reasoned order subsequent to the filing of the petition.
না, তারপর লিখুন, this court, while taking up the petition, has expressed its view that in absence of any prayer, the said subsequent reasoned order dated February 17, 2025, though even if it's taken into consideration, but cannot be dealt with. Poster. Unless either the petitioner files a fresh writ petition challenging the said with a prayer challenging the said impugned reasoned order dated February 17, 2025, or by way of amendment of the writ petition. Also. Paragraph. At this juncture, comma, Mr. Ghosh appearing for the petitioner submits that the prayers can be molded and this writ petition can be proceeded. Poster. To the said submission, this court is also of the view that prayer can be molded where principal reliefs are there. But no sufficient amplification in support thereof is available in the writ petition. First paragraph. Be that as it may, this court proceeds on the basis of the existing records and on the basis of the reliefs claimed in the writ petition.
In 2017, husband had died. Immediately thereafter, my lord, the wife, that is the petitioner, intimated to them, and they also wrote a letter that they will release the entire benefits. By this time, my lord, the son has applied in 2019. Before that, and final, my lord, the papers has been submitted in 2019. They processed the employment. By this time, my lord, in 2021, son has died. Thereafter, my lord, another son has applied for employment. He also, my lord, during this process became sick, and my lord, he also, my lord, did not proceed with the employment. Now, my lord, the wife, that is the petitioner before your lordships, asking the MMCC from the date of death. They, my lord, in view of, in terms of my representation, they wrote a letter that the MMCC would be given. You file the documents. I filed the document, but ultimately they wanted to pay the monetary compensation from the date of application, not from the date of death. This is the, my lord, substance of the writ application. Now, if your lordships kindly come, the last annexure, that is at page 57.
So what, let me hear them, why they are insisting from the date of application? Because date of death is the settled law.
Yes, sir.
Yes, sir.
My lord, may I only just say the chronology of fact which he has given, said, my lord. It's this, my lord. Date of death, my lord, it's on 6th of February 2017.
Date of death is?
Of the petitioner's husband.
Petitioner's husband.
Date of death.
6th
of February 2017. Now thereafter.
And Mike Kartik Baudi, no, what Baudi?
Maya Baudi.
Maya Baudi is there.
Yes.
You're carrying that.
Yes,
yes, I'm also carrying that, man. I'm also carrying that.
6th of February
2017.
2017.
17. Now, my lord, what happened? Death information was given.
1 second. Death of husband. Yes.
Now, my lord, death information was given on 22nd of February 2017.
22nd February
2017.
Death information given to whom?
Death information given to the ECL authorities that he has died, that her husband has died. Now,
yes.
Now her elder son, Ram Dhangar, he applied on 5th of February 2019, 2 years after.
5th of
February 2019.
Eldest son applied.
Yes, 2 years after the death, which is at page 35 of the writ petition.
5th of February 2019.
2019, yes.
This is not after 2 years.
Yes, well, kindly see, 6th of February 2017.
Oh, acha, acha, acha. On 2 years, second
2
year.
years,
Then
2
That's
years.
right. But the time
No,
is
we
5
proceeded.
years.
No, no.
Your
It's not
time is
that.
5
No,
years.
no, my lord, no. Subject to correction, 5 years is the lifespan of a NCWA. But the NCWA does not specify any time period for
Acha. Elder son applied
Hmm.
for compassionate
for
appointment.
compassionate employment. Now,
Act minute.
yes, my lord.
Then what happened?
We process the employment file.
Death certificate at page.
My lord, death certificate is at page. Let me see whether they have annexed. Yes. I don't think they have annexed. Not annexed. I don't
All right. Acha. Information given to ECL.
Yes, page death certificate on page 33.
Acha. Eldest son applied when?
Eldest son Ram Dhangar applied on
5th
5th of February 2019.
Page.
Page 35, my lord.
Then what happened?
We processed it.
His claim was rejected.
No, not at all. We processed it. And we issued a letter dated 13th of May 2019, which is not annexed to this writ petition.
You have annexed.
No, I have not
Oh.
yet filed any report.
You are carrying this.
No, not presently, my lord. This is the information given to me, my lord. If your lordship asks me, then I can file it by way of a report. But presently, my lord, if my learned friend does not
13 May.
13th May and a reminder letter dated 30th
Second, what had happened?
13th May 2019, we issued a letter to Ram Dhangar for rectification of certain shortcomings. For rectification of certain shortcomings, 13th May 2019, which was, I mean, 42 তে আছে.
Yes.
Which was followed by another reminder letter, 30th of September 2019, which is at page 42.
Page
42. 30th September 2019, stroke, my lord, 5th October 2019. Page 42. Now, thereafter, everything was silent. No response from their end, my lord. It was not rectified. 2 years thereafter, by a letter dated 9th of December 2021, which is at page 43.
Yes.
The petitioner informed ECL that the said Ram Dhangar, that is her eldest son, he expired on 27th of September 2021. And
died on
27th of September 2021. The letter is at page 43.
1921.
2021.
Page
43.
Yes.
And by that letter itself, she requested ECL to provide employment to her another son, Shyam Dhangar. Page 43, my lord.
Yes.
Now in 2023, that is 11th of May 2023, 2 years thereafter, my lord, Shyam Dhangar made an application for his employment, which is at page 44.
Yes.
So, after that, we immediately thereafter on 30th August 2023, which is at page 52, we issued a letter.
Okay.
ECL issued a letter on 30th August 2023 to Shyam Dhangar for his initial medical examination. IME. In short, my lord, IME, which is at page 52.
Yes.
He didn't turn up.
Yes.
About a year thereafter, on 23rd of August 2024, the petitioner made application for MMCC.
23rd
August 2024. Page 53. MMCC.
Yes.
Now, so we asked her to submit her documents by our letter dated 7th of October 2024, which is at page 57. Thereafter, my lord, she submitted it, and immediately thereafter,
কি কবে সেটা?
7th of October 2024, we issued a letter, ECL issued a letter asking the petitioner to submit necessary papers and other documents, which is at page 57.
আচ্ছা, where is page 23rd August?
23rd
August 2024.
2024. It is page 53 and 55, both. The same letter written to two of
And 7th of October 24.
24, we issued a letter asking the petitioner to submit page, my lord, 57.
Yes.
Now, petitioner submitted on 15th of October November 2024, which is at page 58. Now, while we are processing, my lord, she filed this writ petition.
Page 15 November.
15th of November 2024.
Page
58.
Yes.
And during while we were processing, my lord, after 15th of November 2024, by that time she filed this application.
Writ petition.
The writ petition, my lord. After a month, very well, after a month, she filed this writ petition, my lord, where that order was passed by the Honorable Coordinate Bench, but pursuant where to be passed the reasoned order. So, my lord, the reasoned order.
So there was no reasoned order before the writ petition was
before
filed.
the writ petition was filed. There was no reasoned order.
Achha.
There was no reasoned order.
Now, what are the reasons in your reasoned order?
Yes, my lord. What are the reasons, my lord? The reasoned order itself, if your lordship kindly takes up the supplementary affidavit filed by petitioner. Page 13. It starts at page 12. My lord, 2.3 starts from 2.3 onward.
Yes.
Well, I'm reading from 2.4. It is found that the employee died on 6th of February 2017, whereas claim of compassionate employment was submitted after 2 years of delay, that is 5th of February 2019. The said claim was also being processed, but the claim died during the period of employment employment could be offered. Next, my lord, 2.5. It is found that even the application submitted for claim of compassionate employment of second son was also being processed, but the said son himself did not appear for the IME. Even despite the non-appearance of the second son, Sri Shyam Dhangar, in the IME, the management asked the petitioner to submit the requisite documents for granting MMCC, but instead she filed the instant writ petition. Thereafter, my lord, 2.7. The provisions related to payment of MMCC is guided by National Coal Wage Agreement, which is formulated by the Joint Bipartite Committee for the Coal Industry, which consists of members of the management of coal industry and representatives of the operating trade union. The rate at which the monetary compensation is paid from time to time is also provided under the NCWA. Now, my lord, 2.8, it is written, as per guidelines for monetary compensation being reference number CIL such and such dated 12/19 December 94, which was issued by the then director Coal India Limited, payment of monetary compensation shall be made from the first day of following month from which application was made for employment or cash compensation till the widow reaches 60 years of age or death or remarriage, whichever is earlier. This was the reason given, but my lord, I must candidly submit, Mr. Ghosh was there in that matter, my lord, in Devanti Kumari, this was set aside, this letter. This was set aside. So this cannot be, this simplicity cannot be reason. Today, as on date, my lord, the reason may be, my lord, two grounds, which one grounds they have not mentioned here, but legally, my lord, there can be only two grounds. There could be, my lord, one, whether this particular petition is at all entitled to MMCC, at all or not, because of the fact that she has renounced, her right to claim the MMCC, because MMCC is in lieu of employment. The moment she consented for employment of her son, but that ground I cannot take right now because of this recent order. I cannot take. So the whatever the recent order has been passed, my lord, it's from the date of application made by the petitioner, my lord. A month later on, they have given, my lord. That's the order passed, my lord, because they were under the impression that we proceeded. First of all, 2017 application made in 2019, we proceeded. They didn't turn up. 2 years thereafter, they came. They said, he has died. You give the employment to my second son. Very well, second son applied a year or 2 years later. Again, we proceeded. Second son didn't turn up. The year after, she comes up and she says, give me MMCC.
Right. I don't find any delay.
No, very much. Your lordship is
I
absolutely
don't
correct,
find
my
any
lord.
delay.
If off the record, I have to say, my lord,
No,
as your lordship
I don't find any
understands.
delay.
Yes.
And compensation is her right under
Yes,
the
yes.
MMCC.
No, my lord, it's right to what extent that I'm not going into in this
No,
matter.
no.
In this matter, my lord.
I tell you, I have already held in Mayabadi.
Yes, I have the judgment. I've gone through that. It's a detailed order passed by your lordship.
And
but
thereafter
factual-
also relying upon Mayabadi, I passed one order.
Several orders, not one.
Show me
No,
one.
they are, my lord, this point was not there, which I am not taking.
No, I will
I will take it up in any other matter. It's an
No.
appropriate matter. This matter, my lord,
I tell you, elder son, right? His employment was not even reached, did not reach up to the stage of consideration because he died. So it did not reach up to the stage of consideration. Second son, he did not turn up. So he relinquished his right of employment. And it has also not reached up to the stage of consideration.
consideration, my lord, that stage reached consideration, but whether it has not reached
No,
as
no, it,
that,
was not, it has not
my lord,
reached.
if it has not been considered, it would not have been proceeded.
That's right. So it has not yet reached its
Any logical conclusion.
logical conclusion.
Logical conclusion.
Right?
That's right.
Now, these schemes are benevolent schemes, welfare schemes. So liberal interpretation has to be
Yes, my
given.
lord. On the other day, I was also, my lord, submitting the same thing.
The gentleman died during employment. Right? So pay him from the date of death.
As your lordship is, my lord. Here, my lord, I will not say anything. From the date next to the date of the death.
Ashok. Mr. Partho Ghosh, Learned Counsel, appears for the petitioner. আগের পার্টটা লিখেছেন তো আপনি? হ্যাঁ, ওইটা আছে তো? কত অব্দি লিখেছেন? বসুন। On the basis of the reliefs claimed in the writ petition. Paragraph. The petitioner is the widow of one Shadhan @Shadhin Dhangar, Dhangar, comma, since deceased, who was an employee of the relevant coal company. Full stop. The deceased employee has suffered an untimely death during his employment tenure on February 6, 2017. Full stop. The death certificate is Annexure P2 at page 33 to the writ petition. এইভাবে লিখবেন। এই দেখুন উপরে ফার্স্ট প্যারাগ্রাফটা। ঠিক আছে, ডেটটাও বোল্ড হবে। Paragraph. After the demise of the employee, the petitioner, being the widow, applied for compassionate employment for the elder son, namely.
No, my lord, widow didn't apply. The elder son himself applied. Ram Dhangar, page 35.
Wait. Even after the demise. না, after প্রথমটা দি হবে না, after demise of the করুন না, the petitioner being the widow, না, employee, comma, death of employee, demise of employee, comma, the eldest son of the deceased employee and the widow, namely
Ram Dhangar.
Ram
Dhangar.
Dhangar, Dhangar. On February 2, 2019, applied for compassionate employment. Poster. By a letter dated May 13, 2019, লিখুন, while the said application of the eldest son, was under consideration and being proceeded with, comma, on December 27, 2021, the eldest son died.
September 27, my lord.
September 27, 2021, the eldest son died. As a result, comma, the application of the eldest son claiming compassionate employment has not reached up to the stage of its logical conclusion. First up. Paragraph. Thereafter, The widow on December 9, 2021 requested the petitioner widow on December 9, 2021 requested ECL for the compassion requested ECL to grant compassionate employment to the younger son, namely
Sham Dhangar.
Sham Dhangar, Dhangar.
Page 43.
Paragraph. On May 11, 2023, the said younger son applied seeking compassionate employment at page 44 to the writ petition. First up. By a communication dated August 30, 2023, ECL informed the said younger son to attend the medical examination.
Initial medical examination.
To attend the initial medical examination. But the younger son did not attend the same. First up. No further claim on account of compassionate employment was subsequently met or pursued by or on behalf of the said younger son. First up. Thus, the claim for compassionate employment by the younger son had also lost its force and did not achieve a logical conclusion. First up. Paragraph. On August 23, 2024, the petitioner, being the widow of the employee, applied for monetary compensation under the MMCC scheme, right?
Yes, madam.
MMCC scheme.
Under the
National Coal Wage Agreement. National Coal Wage Agreement.
No, the MMCC and monetary compensation
scheme is this means employment
or compensation
or MMCC, monthly monetary cash compensation.
আচ্ছা কি বললাম applied for monthly monetary cash compensation MMCC লেটার গুলো বড় হাতের ব্র্যাকেটে for short MMCC full stop হলো in lieu of any further claim on account of compassionate employment at page 53 and 55 to the writ petition. Full stop. By a letter dated October 7, 2024, ECL asked the petitioner to produce the relevant documents at page 57 to the writ petition. Full stop. Paragraph. At this juncture, on November 15, on or about November 15, 2024, না প্যারাগ্রাফ না, সরি, ইসিএল ওই সেন্টেন্সটা হলো on November ওর সঙ্গে ওই প্যারাগ্রাফের সঙ্গে on November 15, 2024 petitioner submitted the relevant documents at page 58 to the writ petition. Full stop. দেখি রিট পিটিশনটা, ও আচ্ছা আচ্ছা। Paragraph. Mr. Partho Ghosh, Learned Counsel, submits. Learned Counsel for the petitioner submits that since the claims for compassionate employment have not arrived at its logical conclusion, in the alternative, in the facts of this case, the petitioner is claiming the monetary compensation from the date of death of the employee. Paragraph. এই অবধি আপনাকে কিচ্ছু দেখতে হবে না, আপনি এইখান থেকে সেম ছাপবেন, কেটে দেবেন এইখান থেকে। The reasoned order এইখানে rider A. The reasoned order, the reasoned order dated February 17, 2025 shows that the ECL is agreeable to grant MMCC from the date of the application being September 1, 2024, submitted by the petitioner, and not from the date of death of the employee. Full stop. Full stop. After considering the rival submissions of the parties, and on perusal of the materials on record, this court is of the view that there is no laches or delay or any inaction on the part of the ECL, on the part of ECL. At all material time, ECL was ready and willing to consider the applications for compassionate employment for the eldest son and then for the youngest son. But those could not achieve, but those claims could not achieve their logical conclusions not for any reason whatsoever on the part of ECL. ECL proceeded bona fide with those claims. Paragraph. In the above set of facts, this court is of the view that in exercise of its power in equity, no interest shall be awarded to the petitioner on MMCC. First. Paragraph. Accordingly, comma, বাস ঠিক আছে ওই অ্যাকর্ডিংলি থেকে না দিদি আপনি এখান থেকে ছেপে দেবেন হলো দেখুন বুঝতে পারছেন কিনা তারপর হয়ে যাবে উইথ দি অ্যাবাভ অবজারভেশন ডিরেকশন দিস রিট পিটিশন নাম্বারটা দিয়ে দেবেন বোল্ডে WPO 214 of 2024 stands allowed, comma, without any order as to cause.
Gentlemen. Look, don't take me, Amish, my lord.
Serial.
One is gone.
Let's say the original set also.
The supplementary affidavit be taken with record.
Supplementary have taken on record. I have recorded them. লিখে নিল হ্যাঁ তাহলে কি আচ্ছা অ্যাকাউন্টিং কি লিখে কি
বললাম
একবার দেখি কাগজটা আরে হ্যাঁ এটা দিন এটা জাজমেন্ট ফর্মে হবে একদম J2 তাই তো এইখানে একটা লিখে দিন রাইডার কত বললাম এটা তাই হোক রাইডার এ বলেছি আগে তাই তো রাইডার বি Purun. Resultantly, comma, the reasons shown by ECL for not granting MMCC benefits from the date of death of the employee stands set aside and quashed. And quashed. শুধু দিলাম যখন পুরোটা দিয়ে দিই।
Unless it is quashed, that order can be.
Why not follow normal serial?
Next.
You would recall, my lord, it is that matter, my lord, where, my lord, the petitioner is an aspirant, my lord, to be appointed as a lower division assistant of this honorable court, my lord. My lord, the issue, my lord, is with regard to just one question, if your lordship would recall, my lord. Question number 70, my lord, the question was that if in a family, my lord, there are 7 sisters and each sister has one brother, then how many children are there in the family? My lord, in this background, lordship had, my lord, passed an order on 6th of May 2025. Your lordship takes the order once, my lord.
What is your instruction?
My lord, I have already
filed a
submitted a report. On the other day, my lord, adjournment was sought for filing exception.
কোথায় report দেখি? Exception filed?
No, my lord, they have filed a report. I'm coming to it, my lord.
No,
If
will
your
you
lordship-
file exception?
Well, I would want to file a composite exception because this.
Sir, if you want to file exception, don't waste the time. Take time and straightway file.
Kindly hear him, lord. What I'm similar, this report that has been filed, my lord, in my humble, my lord, submission, my lord, this is not in terms of the order passed by your lordship, my lord. It's not in terms. So
If it
my lord,
is not in terms of my order, then they will face the consequence.
kindly takes, my lord, the order passed on 6th of May 2025 once, my lord. Paragraph 1, my lord.
Yes.
The order says, my lord, considering the issue involved in the writ petition and considering the reliefs and claim therein, the respondent number 2 shall file a report in the light of the case made out in the writ petition with supportive documents and records in support of their stand. Lord, in my, my lord, if your lordship takes the report, my lord, there is neither any, my lord, document, my lord, supportive document, nor, my lord, any record annex, my lord.
So it will, I will draw adverse presumption.
Then lordship gives me a week's time, my lord, I will file the exception.
Why you will allow them to cure it?
Then your lordship gives me a week's time, my lord, I'll file an exception. I thought, my lord, if they file, my lord, I'll file a composite.
On the prayer of Mr.
Huda, HUDA.
Now, on the prayer of Sheikh Aftabuddin.
Sheikh Aftabuddin, my lord, is the advocate. Record.
Oh, prayer, Mr.
HUDA, Huda.
You please give your
It's
name.
there in the order, my lord. The name I'll give. 6th of May 2025 order. I should give the name.
Yes. Huda. The petitioner shall be at liberty to file its exception in the form of affidavit to the report on or before July 30, 2025. The matter shall appear under the heading court application under Article 226.
I can file it within a week, my lord.
On August 21.
August 21, July.
But can I, my lord, my lord, very humbly pray for a, my lord, shorter date? The reason being, my lord, the second phase is still pending, my lord.
August 7, 2025.
Like, deeply opposed, deeply opposed.
তোরা সাবমিশন করবি তো? তোরা submit করবি? তোরা তো পিটিশনার, তোরা ফার্স্টে বলবি। হ্যাঁ, দ্যাট ওয়াজ অনেক দরকার। তোরা বলবে না? বলাটা ভুলে গেছে, তুই একটু রিমাইন্ড কর কি বলতে আছে।
Yes. আজকে তারিখ কত?
কি ধ্রুব বল ওর আগে থেকে চালা। হ্যাঁ, তোরা কিছু বলবি না?
Yes. কবে শেষ হয়েছে সেটাই খুঁজে পাচ্ছি না। June. এরকম আমার আলাদা নোট ছিল দেখুন তো।
আজকে তো ওরা বলবে তো, কেন ওরা বলার পর তো একবার না, আজকে তো ধ্রুব বলবে, আজকে তো ও বলবে।
ফাইল কোথায়?
মাস্টার ফরওয়ার্ড হয়ে যাবে।
আমার আমার পরের লোকরা যেমন ভাবে সাইড চেঞ্জ করছে দেখুন, আমাকে কম্পেল করেছে সাইড চেঞ্জ করতে। সাইড চেঞ্জ করাচ্ছে এই মামলার ভয় চলে গেলাম। না না,
Anyway, was it when it was went out? Was it argued before any other court?
No, I think it appeared before
হ্যাঁ হ্যাঁ, 19 নম্বর কোর্টে।
where it went with the change of determination to Justice
Yeah,
Parthasarathi Sen. His lordship was pleased to release the matter, then it has been assigned to my
because the entire bunch of note is not there in the file.
I'm sure they have taken it out.
Entire bunch of note.
হ্যাঁ, তো হারবি বলে সব বার করে দিয়েছিস। হ্যাঁ,
তাহলে কি হবে?
Mr. Mukherjee have to start again.
Yes, Mr. Mukherjee then has to start afresh.
No, it's there. What I have taken is there, but
Lord, it was in 4 volumes, Your Lordship, because I am seeing only 1 volume. There were 4 volumes. Is it there? The writ petition is in 4 volumes.
4 ভলিউম রিট পিটিশনও নেই আছে তো ঠিক আছে দিন না
এরকম প্র্যাকটিস জানতাম না।
Now, we'll have a short recap. Then where I'll take your lordship through the documents.
We start করার আগে এই সেকেন্ড রাউন্ড অফ লিটিগেশনের ফার্স্ট রাউন্ডের নোটিশ অর্ডার এগুলো সব এসে আমরা রাখাইনি, যার জন্য আমরা একটা সাপ্লিমেন্টারি অ্যাফিডেভিট রেডি করে রেখেছি। তুমি যদি বলো আমরা ফাইল করবো।
Well, this pertains to Millard, certain land, pieces of land, Millard, which according to the state has vested under escheat. Now, Millard, as your lordship knows, Millard, these are guided by the West Bengal Escheat and Forfeiture of Movable Property Act, where the proceeding was initiated, Millard, which was challenged in the earlier round, which was challenged, Millard, by the Kolkata Port Trust, but by way of a writ petition. Now, Millard, the writ petition was disposed of, Millard, by a
yes
judge.
then up to went up to Supreme Court. Supreme Court set aside and sent it back lock, stock and barrel. Said that a proper notice should be issued.
Millard, the Honorable Supreme Court, in my very humble submission, had only directed that a proper sketch of the land.
Show me that order.
Yes, please have a look to me at page number 75. It starts at page 75 in the first volume.
Show me the order of the Supreme Court.
Yes, at page 75.
Dated?
This would be dated 9th February 2024.
February 2024. Yes.
Please take the second paragraph at page 75. A show cause notice was issued under section 3 of the Act. The appellant replied. Thereafter, the competent authority passed an order rejecting the contentions raised by the appellant and holding that the property subject matter of the notice will vest in the state of West Bengal. The appellant filed a writ petition before the learned single judge.
Where, sir?
Well, I am at page 75. Second paragraph at page 75.
Yes.
Well, first is show cause notice, then reply to the show cause notice, then the competent authority rejects the contentions, holding that the property subject matter of the notice will vest in the state of West Bengal. My lord has found that. The appellant filed a writ petition before the learned single judge of the Calcutta High Court and raised the issue of jurisdiction. The learned single judge allowed the writ petition. One of the findings, the Honorable Supreme Court quotes the finding. Then thereafter, after the quoted portion, the respondent state preferred an appeal. Before the division bench of the High Court, the appeal has been allowed by holding that the remedy of the appellant is to prefer a statutory appeal against the aforesaid order. Learned senior counsel appearing for the appellant invited our attention to the show cause notice. It is submitted that in the show cause notice itself, it is accepted that the appellant is shown as the owner of land measuring about 12 bighas 7 katas. He pointed out that the notice is in respect of the remaining portion. His submission is that the description of the remaining portion with reference to its area and boundary by showing it on a sketch map was not incorporated in the show cause notice. But this is the subject matter before the Supreme Court. This is very important for me. The grievance was that a proper sketch map was not enclosed with the show cause notice. He would therefore submit that the show cause notice was illegal apart from other contentions which the appellant raised on merits. Learned senior counsel appearing for the state submitted that apart from the fact that there was sufficient identification of the property in respect of which notice was issued, the appellant produced documents of title only in respect of an area of 12 bighas and therefore the order of 29 January was passed. We have perused the order of 29 January. The order records that the same is in respect of lots B1 and B2. In the said order, the land subject matter of show cause notice appears to have been divided into 3 lots. That is lot A, lot B1 and lot B2. However, we find that in the show cause notice, there is no such description. Moreover, a sketch indicating the area over which the claim for escheat is being made was not annexed to the show cause notice. Therefore, it would be appropriate if the first respondent is permitted to issue a proper show cause notice clearly describing the property in respect of which escheat is claimed by the government under the 2012 Act. It would also be necessary that the state annexes a proper sketch of the property in respect of which claim is made. Only on the ground that the show cause notice is defective, we set aside the order. It is obvious that the state government is not disputing the title of the appellant in respect of an area of 12 bighas and 7 kathas. Therefore, a fresh notice can be issued for the remaining area. Therefore, the orders of the division bench and the single bench as well as the order.
So what does it mean? It is obvious that the state government is not disputing
Yes.
the title of the appellant.
In respect of 12 kathas, 12 bighas, 7 kathas.
Who was the appellant?
But appellant over the Port Trust.
Port Trust was the appellant.
Which is recorded, Millard, at page 76.
Port
Middle
Trust
paragraph.
was the appellant before the Supreme
Before the
Court.
Honorable Supreme Court. Therefore, so and so set aside. After a fresh notice is served, the appellant will file a reply within so and so. Thereafter, adjudication shall be made. Order of the competent authority shall be served. If any adverse order is passed, the same will remain stayed for a period of 30 days from the date of service to enable the appellant to challenge the same in accordance with law. We make it clear that we have made no adjudication on the merits of the controversy and the adjudication is confined to defects in the notice on the basis of which the impugned order was passed, hence all questions left open.
Yes.
Therefore, my lord, the direction of the Supreme Court is that give a proper identification along with a sketch map.
Clearly describing.
Clearly described. So that, my lord, there is no ambiguity, opaqueness in the understanding of what is devolving on the state by escheat. Now, the fresh notice your lordship will find in terms of the Supreme Court's direction is at page 81.
Dated?
This is dated 2nd of April 2024.
Right. Then reply.
Well, the reply your lordship would find reply to the annexed name. Yes. Well, reply was not annexed, but I think it was handed up separately. Now, please have a look to the show cause notice, the fresh notice at page 81. But it's in the form of recitals. Please take the last recital at page 81.
আগেরটার সঙ্গে পাশে রেখে একটু কম্পেয়ার করা হবে যে আমরা followed the same pattern except for the recital which gives the history. There's no defect. Sketch টা
কিন্তু এটা যশোর কাছে তো নেই।
না নেই, এটা original copy.
Milord, we have prepared a supplementary affidavit for your lordship's consideration, annexing some of the documents which are not on record. For example, the first show cause notice which went up to the Supreme Court, so that a comparison can be made. The other few documents, Milord, we have.
Then they have to be granted an opportunity.
Milord, we have merely annexed it, not in the, or we can show it to your lordship, Milord, without referring to this supplementary affidavit. দিয়েছে
আগেকার নোটিশ আগেকার অর্ডার এগুলো
একটা পাতলা সাপ্লিমেন্টারি অ্যাফিডেভিট দেখ।
আমাকে কি দেওয়া
Well, what we have over here is the previous notice in the earlier round, that notice, their reply to that notice, and minutes of certain meetings held before the estate officer. And the
How are they relevant? Minutes, how are they relevant?
no, the minutes are not relevant as such.
part of their briefing. It's part of their reply.
I'm told me it was part of the reply. If required, Milord, we'll rely upon them. If not, Milord, we'll not do that. Very well. When it is prepared, let it be there, Milord. If therefore, Milord, coming back to page 81, please take note the last recital at page 81. And whereas the competent authority is prima facie satisfied that the provisions of the Act is applicable in respect of the area mentioned in the schedule herein below, and therefore desires to cause inquiry as to whether the facts as stated in clause so and so would attract the operation of section 3 of the Act exist in respect of the area mentioned in the schedule. And whereas upon inspection and survey conducted in respect of the land and buildings as aforesaid, the competent authority under the Act is satisfied that the relevant provisions of the Act is applicable in respect of portions of land delineated in green, comprising of an area of 20.82 bighas, and portion of the lands delineated in red, comprising in an area of 62.49 bighas, excluding internal roads, as set out more fully and particularly in the sketch plan, appended to this notice and described in the schedule herein below. Then where the schedule is there are two schedules, or in the schedule mirror, there are two plots of land, butted bounded with so and so. Then after that, and whereas the competent authority therefore desires to cause an inquiry as to whether the fact or facts as stated in clause G of section 2 as would attract the operation of section 3 of the Act exist in respect of the aforesaid land. Therefore, in pursuance of the order dated 9th of February 2024 of the Honorable Supreme Court in civil appeal in the matter of so and so, notice is hereby given to the effect that if any person, organization, entity, authority has any claim, right, title or interest whatsoever or howsoever over the lands, he may present his case before the competent authority. Page 82A is, Milord, the sketch that we annex along with this notice in compliance with the order of the Honorable Supreme Court.
Yes, sir.
Now, Milord, the writ petitioners, Milord, they give a reply to this, which is by way of a separate document. Now, finally, Milord, the order under challenge was passed on 10th of February of 2025. That, my Lord, will find at page 481.
Impugned order dated
10th February 2025 in volume 4.
10th February 2025.
Page 481. Yes. The genesis of the present inquiry proceeding under subsection 3 of section 4 of the Act can be traced back to the notification of 29th January 2019 issued by the Joint Secretary and the competent authority under the Act, whereby the land and structure comprising an area of 29.26 bighas identified as plot B1, butted and bounded by so and so, so and so, so and so, and land and structure comprising an area of 84.98 bighas identified as lot B2, butted bounded by such and such, forming portions of premises numbers 68 and 69, Strand Road, Kolkata, were vested to the state by escheat or lapse. Then, Millard, it was challenged before the Honorable High Court, that is noted. Then the Honorable Single Bench's order is noted at page 482. Then the Honorable Supreme Court's order is also noted at page 182. Order 482, I'm so sorry. Then Miller, after quoting Supreme Court's order, Miller, please comes to Miller, page 483. After the quoted portion. Pursuant to the solemn order passed by the Honorable Supreme Court, the SSR Collector called upon the SMPK authority by notice in writing to participate in survey of the area of land which was scheduled to be conducted on 1st of March. On the date so fixed, admittedly the representative of the state, the representative of KMC and SMPK were present, but no effective survey could be done. However, on being objected to by SMPK, on that day, the holdings of the area of the land were dismantled, etc. A further notice was given. We can skip over that paragraph. Kindly take the last 3 lines in that page. Such contention of SMPK does not seem tenable since the document available in the record reflects that the notice dated 6/3/2004 was received in the office of SMPK on the very day, but SMPK did not participate in the survey scheduled on so and so for reasons better known to it. On the basis of the survey conducted on 7/3/24, the chief valuer, etc., furnished the sketch map of the area of land drawn to scale dated 12/3/2024, which was made part of the show cause notice. In compliance with the solemn order of the Honorable Supreme Court, show cause notice number, etc., was given. Then where the schedule is quoted. Now we can skip over, Millard, a few paragraphs. Please take note, page 485. Where the show cause notice was also published in the newspapers, which is a statutory requirement that is also noted in page 484 at the bottom.
Gazette or আমরা gazette and করেছি সব জায়গাতেই করেছি
But this is a requirement under section 4 subsection 3. This has been complied with, Millard, which is noted in page 484. Now, there was a KMC report which your Lordship would find word at page 485. Please take the second paragraph at page 485. In relation to the sketch map submitted in the record by the chief valuer and surveyor of the where I was reading at page 485, the second paragraph there.
On initiation.
The paragraph thereafter, in relation. In relation to the sketch map submitted in the record by the chief valuer, Kolkata Municipal
On initiation of the instant inquiry proceeding, SMPK authority duly represented by Sergeant, this apart assessor collector.
These were the persons who were present.
Then, in relation to the sketch map.
Sketch map submitted in the record by the chief valuer of the Kolkata Municipal Corporation, the assessor collector furnished the following report. On close scrutiny of the sketch map prepared by the chief valuer and surveyor of the Kolkata Municipal Corporation, it looks like that only one portion is assessed amongst the area shown as Zone X, delineated in green border and measuring 20.82 bighas, and that assessed portion is recorded against the premises number 67/5 Strand Road bearing SSC number situated at ward number 45 and stands recorded in the name of Kolkata Municipal Corporation and used as KMC Storm Water Pumping Station. The rest portions Zone X appeared to be not assessed by KMC. The report further speaks that only one portion is assessed in the area shown as Zone Y, delineated in red border and measuring 62.49 bighas, and such assessed portion is recorded against premises number 67/1 Strand Road bearing SSC number situated at ward number 21 and stands recorded in the name of Governors of Mayo Native Hospital, Lessee, Eastern India Institute of Medical Science and Research Hospitals Limited. The rest portion of Zone Y appeared to be not assessed by KMC. The report further speaks that two more premises exist in KMC records, which are by numbers of premises numbers.
So these are outside the escheats.
No, it is within the escheat, but some portion are assessed by the KMC, which had the holding numbers, and some portion did not have or were not assessed by the KMC. This is what is recorded.
Has not been assessed does not mean that it will not be assessed.
It can be assessed tomorrow.
Tomorrow,
Yes.
right?
Yes.
Now, let's say 2, 3, 4, 5 properties are mentioned like that by KMC. What about the rest?
Rest, according to this report, were not assessed by the KMC.
That does not mean assessment not being done does not mean taking away the title.
No, certainly not. Certainly.
Right?
Certainly.
So one person may be there who has a 3 katas of land, or there may be a 6 stories building in which she might have a 600 square feet. Possible. Considering the area, both of us we know. So what will happen to them?
Milord, assessment, as your lordship know.
Because these objections, no, I'm not on assessment, Mr. Advocate. I'm on that the notice has to be such on the face of it. You will understand, yes, my 600 property is included, 600 square feet is included.
Right.
On the face of it.
Yes. We need to understand, Milord, from the reply given to the show cause notice as well as the pleadings of this writ petition as to whether the port trust felt that I cannot understand what you are saying or what is the extent of the notice or which portions are covered by this notice. That is not the case.
No, but this is a notice.
Yes.
For the world at large. For the world at large. So the moment it is a notice for the world at large, when it is placed before the court will read it. Whether it is it comes to the mind of the court that yes, it is a sufficient notice. That's the first test. First test should be that. Even if court trust takes an objection or does not take an objection. So to that, what do you say, sir?
Yeah, please go on.
পর যখন কালেক্টর কম্পিটেন্ট অথরিটি অ্যাক্ট করবে তখন ইন্ডিভিজুয়াল নোটিশেস যাবে প্রত্যেক লোককে। সেকেন্ড স্টেজে তার অবজেক্ট করবে, তারপর শুনানি হবে। থার্ড স্টেজে আবার হচ্ছে জেনারেল নোটিস। সো 3 স্টেজ নোটিস।
Here are the first. Milord, the first is, this is, Milord, this notice, present notice, which is covered by section 4, is pursuant to an order passed by the Honorable Supreme Court. Now, Supreme Court had made it clear that give a sketch map and a proper schedule over the property.
Clear notice.
To that, Milord, I don't think, Milord, the Port Trust raises any grievance that the Supreme Court's order has not been looked into, or that from the notice itself we are unable to find out which portion of the land is sought to be cheated under the Act.
So, but this is a statutory notice?
Yes, I'll come to these different stages of the statute. I'll come to the different stages of.
Is there any format?
Well, there is a rule.
No, but is there any statutory format prescribed under the schedule?
I don't think so, because the rule does not provide. Rule does not provide. Yes. Yes. Take it. But there is no statutory notice.
General sir, public order.
Yes, sir.
Yes. Now, but if your lordships desire, Milord, I can immediately answer, Milord, what has fallen from the court. That the statute is annexed at page 84, 83.
Yes.
But please take, Milord, section 4 at page 86. First is, Milord, causing an inquiry under 4 subsection 1. It shall be the duty of the collector or every district to send monthly reports, etc., etc. Any person whatsoever may send information to the collector in this regard whenever the competent authority, Milord, if your lordship may take, Milord, towards the middle of subsection 1, Milord, a sentence starting with whenever. Whenever the competent authority on any report or on receipt of any information. Whenever the competent authority on any report or on receipt of any information from any source or on his own motion is satisfied that the provisions of this Act applies to any property lying within the state, he shall cause an inquiry to be made as to whether the fact or facts stated as stated in clause G of section 2, as would attract the operation of section 3 of this Act, exists or exists, and on being satisfied on such inquiry that such a fact exists, he shall pass an order accordingly, recording that such fact exists, on which order recording the existence of such fact, the property shall belong and be transferred automatically to the state government without any further act document being required. This is the first preliminary stage. Then, Milord, what should the inquiry comprise of is stated in subsection 2. Now, please take subsection 3. We are at this stage now. For the purpose of such inquiry, the competent authority shall cause to be published in the official gazette or in any 3 newspapers, where though it is all, Milord, we have done both. Why having wide circulation in the locality where the property is situated, a notice informing the public in general of such report or information having been received, and that an inquiry is proposed to be held on the expiry of not less than 7 days from the date of publication of such notice, and the time and place of such hearing, and the particulars of the property concerned, the newspapers should be so chosen as to ensure that they are in English, Bengali, and Hindi or Urdu respectively. So this is informing the world at large. Now comes, my lord, the show cause notice, which is the subject matter of the present proceeding, which is subsection.
The notice under subsection.
Kindly take, my lord, the notice once more. Please comes to, my lord, the impugned notice at page 81 under subsection 3 of section 4. Page 81.
So this is a notice under subsection 3.
Yes. Now the gazette notification was made, newspaper publication was also done. হ্যাঁ, ওখানে একটা দেখেছি, অ্যানেক্স করা কিছু নেই। আচ্ছা, ঠিক আছে। Now please take, my lord, the procedure after the notice, which is subsection 4 of section 4. Any claimant or person intending to appear in such inquiry with an intention to oppose escheat or lapse and automatic transfer of title to the government may appear on the date of such inquiry at the time and venue fixed, with a written representation containing the particulars of his claim and the right which he claims in the property, including reasons of his opposing escheat or lapse, as the case may be, and shall enclose with such representation a copy of all document that he relies upon, and shall also produce before the competent authority the originals of such documents. If the copy of any document is not enclosed, then the claimant or the person shall not be entitled to rely upon it. The competent authority shall thereafter pass an order recording his satisfaction that such fact as mentioned in clause G of section 2 sufficient to attract the provisions of section 3 exists or does not exist. Explanation is whatever interest is sufficient to maintain an application for letters of administration or to the estate of the deceased or obtain winding up or dissolution of body corporate, etc., etc., shall be held to be an interest sufficient to maintain an objection or representation against such escheat or lapse in the preliminary inquiry. Yes. Now, this is what is under challenge before my lord. Now, what is the first remedy or first forum or the forum of first instance? That is, my lord, subsection 6. Now, kindly have a look to me at subsection 6.
Yes.
No, subsection 5. Subsection 5. The decision of the competent authority shall be subject to an appeal before the appellate authority, which shall be made within a period of 30 days from the date of publication. But that is why the Supreme Court was pleased to direct that whatever order is passed, that will be stayed for 30 days. Within a period of 30 days from the date of publication of the gist of the order in the manner mentioned in subsection 5, provided that the appellate authority may allow for sufficient cause being shown an appeal to be preferred within a further period of 30 days, but not thereafter. The appeal does not have to be in a particular form, but shall contain XYZ. That is, yes. So, this is the first forum of remedy. Our submissions on the last occasion was, and my lord, we would like to make that submission once more, that the immediate forum that the writ petitioners have is subsection 6 of section 4. Now please take subsection 5. The subsection 7, I'm so sorry. Subsection 7. The decision of the appellate authority shall be final and shall not be interfered with except by the High Court exercising jurisdiction under 226, 227 and the Supreme Court under 136. Then no suit or proceedings apart from the aforesaid shall lie, or civil court jurisdiction is barred. Then comes the next stage, that is section 5. Here kindly see, there is a question of serving notice. On an order
That stage has not yet
not yet reached.
So let's not
Yes,
discuss.
yes,
Let's concentrate.
yes,
Up to 7.
yes,
Up to 7.
yes. Milord, your lordship was on the last occasion also, Milord, this was expressed by the court, that what happens to the persons who are in possession? Those are, Milord, taken care of, Milord, in the subsequent sections. Apropos your lordship's observation, may I place only 5, 6 and 7 sections? Well, that may dispel the doubt from the mind of the court. That this is, at this stage possibly, Milord, none of the rights of the other parties who may be in occupation, who may have some other interest.
Why?
Yes, please take note subsection 5. I'm sorry, section 5.
I tell you why.
Yes.
When a notice basically is a character of in rem, published in the newspaper or published in the official gazette, whatever. To that, nobody has objected, neither do I have taken. It's published according to the statute. The moment a notice is published, a person reads the notice. At a first glance, it must strike to his mind that, oh, this is the area, this is the, I might have, my 600 square feet is there in that premises or something like that. Some more on that. More so when no statutory format is provided for. So, the notice must be such. Now, kindly take one expression from the Supreme Court.
Yes, sir. Page 75.
Page 75. Moreover, a sketch indicating the area
yes,
for which the claim for escheat is being met was not annexed to the show cause notice.
Right.
Then what is the direction of the Supreme Court? These were the contentions, submissions. Therefore, it will be appropriate if the first respondent is permitted to issue a proper show cause notice clearly describing the property.
Yes.
In respect of my escheat.
And a sketch map.
Whatever. Proper show cause notice clearly describing the property. Now, and keeping it in mind that there is no statutory format. There is no statutory format. So a person, a normal person,
yes,
a common people, common man,
yes,
when sees this notice, he must, at the first sight, it should strike his mind that there is my property. 600 square feet or a 350 square feet is there. I'm more on that.
But number one is the notice has a schedule.
No doubt about it.
But it bounded with this, that, etc.
With a sketch map.
With a sketch map. Insofar as the writ petitioners are concerned, my lord, there is no lack of understanding of the area or the portion of the land which is escheated. At least there is no pleading. I could not find out any pleading. My lord, if your lordship may kindly take a portion of the pleadings, please come to my lord page number 12, 11 of the writ petition pleading. Where the case made out is the jurisdictional facts.
Which part?
My lord, page number 11, para 6 onwards. The fundamental case made out is the jurisdictional facts are not disclosed in the notice. Please look into my lord, para number 6. The notice does not meet any of the prerequisites.
Kuda.
What is found, my lord?
After which paragraph?
My lord, page 11, para 6.
Hmm.
The notice does not meet any of the prerequisites within brackets jurisdictional facts so as to meet the preconditions for attracting the provisions of the Act. Then they are saying, what are the jurisdictional facts? The jurisdictional facts necessary to invoke the provisions are to be found in sections 2G 341, which can be summarized. The property must have belonged to either a person who died intestate without any legal heir, or belong to an artificial person which has been dissolved, wound up, or has become defunct, or the artificial person has ceased to exist, or is unable to hold general meeting and reconstitute its executive committee board of directors consecutively for 5 years. Now, this is what is the understanding of the petitioner in regard to the jurisdictional facts. We will not dilate on that. Let us assume for argument's sake that this is what is meant by jurisdictional fact. All these jurisdictional facts must be there. Let us assume for argument's sake for the time being. Now, what is the grievance? That these jurisdictional facts are not available. Kindly say take the next paragraph, 8. In the notice, there is no recording as to the existence of any of the jurisdictional facts as aforesaid, in the absence whereof the provisions of the Act cannot be invoked. These jurisdictional facts, in fact, do not also exist in the present case. Para 9. Apart from that apart, there is no non-compliance of the procedure prescribed under the Escheats Act, which is summarized as below, where the statutory non-compliances, my lord, are pointed out in subparagraphs A, B, C, D, and E. What are the alleged statutory non-compliance? Monthly reports not sent. On the occurrence of death, dissolution, winding up, being defunct, etc. Then B, satisfaction of the competent authority not reached. Then C, inquiry commenced on a public notice informing the general public of such report, not done. Then inquiry should be by the competent authority who will have the powers of a civil court. Then competent authorities to pass an order recording his satisfaction. Now, this is the statutory non-compliance according to them. First is jurisdictional facts not stated. Second is there has been statutory non-compliance. Now, kindly simulate what is the effect or how it harms the port trust that is stated. I skip over 10 and 11 because these are on survey. 12 also I skip over because these are all preliminary objection. Now they come and say from para 13, without prejudice to the preliminary contention that the jurisdictional facts required for the provisions of the Act together are altogether absent, the title of the petitioner to the land is detailed hereinafter. Therefore, insofar as the Kolkata Port Trust is concerned, there is no misunderstanding or lack in understanding what is sought to be escheated. What they are doing is they are aware of the extent of the land to be escheated. Therefore, they are trying to demonstrate their ownership over the land. How? Kindly take para 15. By virtue of indenture dated so and so, whereby the Secretary of the State for Indian Council grant unto the Commissioner in the port of Calcutta a vast tract of land between so and so place, all land situated between Hooghly on the west and Strand Road on the east, 7 except 5 parcels of land. However, through further indentures, 4 plots were also vested in the predecessor of interest of the petitioner. Then the indenture is annexed. Then para 16. By virtue of another indenture, the Secretary of the State granted unto the Commissioner such and such. Then comes para 17. Another indenture dated 25th March 1876, so and so granted such and such. Then 18, another indenture granted such and such.
These are in support of their title.
Yes. Therefore, what they say is, please take para 20 now and para 21. From the aforesaid, it is evident that by virtue of the above deeds, dated etc., the petitioner is the owner of the having unbridled right title interest of the lands in respect of which notice has been sought to be issued by the respondents. Since the time of grant, this is very important, apropos your lordship's prima facie observation. Since the time of grant, that is since 1874, 1876, 1884, and 1910, the petitioner is exercising all rights as the owner of the subject land. Therefore, my lord, insofar as the petitioners are concerned, the petitioner is concerned, they don't say that I cannot identify the land. Please come out with proper more details. Whether, my lord, by virtue of these indentures, they can establish their ownership is a different question.
issue.
Yes, I will not invite your lordship to adjudicate on that, or my assessment or my report is proper in respect of my observations in respect of these reports. I will not invite your lordship on that. But on the prima facie point, my lord, that your lordships have been pleased to observe, is that, my lord, from the pleadings itself, it is apparent that, my lord, the Kolkata Port Trust was in no way affected by the schedule or the description of the property,
Or there is any misunderstanding on their part.
So there is no lack of understanding insofar as the expense width of the property, my lord, that is sought to be estimated. And the endeavor is to establish their own right over the property. They are not saying that, no, this portion may be of someone else, that portion may be of some other person, nothing. They are clear in their approach. This is whatever you have said. See, these are my documents of title. That's what they're saying. Whatever you seek to escheat is our property. The grievance is something else. That where is the mention of your jurisdictional facts in the show cause notice? Because of this lack of or non-mention of jurisdictional facts, according to them,
Not a jurisdictional fact, sir.
Yes.
That there is one property marked as X.
Yes, my lord.
Premises number such and such, whatever, let's say compositely as X.
Yes.
Is it not required to be mentioned? that X property is there. It may not be of port trust. It may not have any connection with port trust.
May I please have a look to the definition of escheat under 2G. Escheat with all its grammatical variation means the automatic transfer.
1 minute.
Yes.
Yes, sir.
Escheat with all its grammatical variations means the automatic transfer. But this is not through any proceeding. The transfer happens because no property can be ownerless even for a minute. Therefore, the moment there is an absence of owner, the property devolves on the government or the state. Therefore, Miller, it is an automatic transfer to the state government of property of a person who dies intestate without any legal heirs according to his personal law, and in case of an artificial person such as a corporation, trust, association of person, or society recognized by law to be capable of owning property, whether in its own name or in the name of any governing body or office bearer by whatever name called, or otherwise, the transfer to the government of the property of such artificial person on its dissolution, winding up, becoming defunct, whether by operation of law, declaration, or in fact, including the circumstances mentioned in section 3, such fact being one that the competent authority will have power to determine in the manner prescribed. Therefore, A, B, C, D circumstances, property automatically gets transferred to the government or the state. Now, the demand of the writ petitioner is that you have not told me how it has gone to the state.
No, so are these not jurisdictional facts?
Well, this is an.
Just I'm giving
I'm
an
sorry. I'm sorry.
example,
I'm sorry.
Mr. Advocate.
Yes.
Of a person, just I'm taking, of a person dies intestate without legal heir. Is it not a jurisdictional fact? Of a person died intestate without legal heir.
May I say this, Millard? Here, Millard, the transfer takes place by operation of law.
That's right. No, I'm saying.
No, please have a look.
Is it not to be construed and taken as a jurisdictional fact?
But if your lordship is having a constitution, please have a look toward Article 296.
Yes. এটা না ঝাড়ন রাখবেন বুঝলেন
আছে?
হ্যাঁ আছে দিন আজকে কিছু নেই
না, আজকে নেই। Everybody is in good health.
Article 294,
296.
296.
ও ভালো কথা মনে করে দিয়েছি।
Yes, sir. Yes, sir.
But this is the parent provision.
Yes,
This was
yes,
this
yes,
was
yes, yes, yes.
subject as hereinafter provided any property in the territory of India, which, if this constitution had not come into operation, would have accrued to His Majesty, or as the case may be, to the ruler of an Indian state by escheat or lapse, or as bona vacantia for want of rightful owner, shall, if it is property situated in a state, vest in such state, and shall, in any other case, vest in the Union, provided that any property which at the date when it would have so accrued to His Majesty or to the ruler or an Indian state was in the possession or under the control of the government of India or the government of a state shall, according as the purposes for which it was then used or held were purposes of the Union or a state, vest in the Union or in that state. Explanation in the article, ruler, etc., have the same meaning as Article 363. Therefore, Miller, this is automatic. Ownerless goes to the state.
In absence of a rightful
owner. Now, this being, Miller, the parent provision, where the procedure or the mechanism is in the statute. Miller, the state, in my very humble submission,
Yes.
where the state, Miller, does not become the owner by escheat because of the statute.
Constitution.
And what is this? Why this statute?
Source of everything.
The statute is only to ensure that if somebody is claiming a right, he gets an opportunity to demonstrate that.
Yes.
Therefore, the statute, Miller, cannot overlap the constitutional provision. Miller, may I seek an indulgence? But the matter is fixed at 4 o'clock. So, if your lordship may kindly permit Mr. Sen to, Miller. No, Mr. Sen can, Miller, carry on for 20 minutes, Miller, if your lordship permits.
Next date? Next.
I'm sorry?
Aji ki bar? কোনটা? নেক্সট মঙ্গল বৃহস্পতি কি আছে? শুনুন, 14th August রাখবেন না কিছু, একদম কেটে রাখুন। আমি ওটা আপনার ডায়েরি,
আজকে তো মঙ্গল 15
কিছু বললেই মনে করাবেন না।
মঙ্গলবার বৃহস্পতি হতে পারি।
কেটে রাখুন 14th August।
খালি মঙ্গল আর বৃহস্পতি
বিশাল থাকছি না বানান
আমি থাকলেও করতে
29 করবে 20 বা 31
এটা কি বার?
22 তারিখ
18 তারিখ কি আছে? 24th.
But 24th, my lord, the difficulty is where if it is taken up after 3 o'clock, I will be available. But very difficult to say
It
that.
will remain in list.
Let it remain in the list, my lord.
It will remain in list. Let it junior
24th, Mr.
proceed.
Sen is not here.
24th.
West Bengal highway.
J highway. He'll be on the highway.
সরকারের দায়িত্ব।
28, 29.
Very good. Very good.
Ask.
My lord, may I take your leave?
Mr. Your name? Dhruv Chadda. Dhruv Chadda, learned advocate, appears for the petitioner. Paragraph. Mr. Kishore Datta, Kieta, learned advocate general for the state, has commenced his submissions, and he shall continue on the next day. আচ্ছা ওখানে করে দিন Mr. Kishore Datta, learned advocate general, with Mr. Shamrat Sen, learned senior advocate, and no, additional. Oh, sorry, I'm guli hai.
Assistant additional.
Assistant additional advocate general. Learned assistant advocate, assistant additional advocate general for the state. Has commenced his submissions, and shall continue on the next day. Full stop. কবে রাখলাম 29th কিছু নেই তো শিওর আমার অ্যাপেলেট সাইডে কি আছে তারিখ কিছু আছে 29 জুলাই দিদি 29 জুলাই কিছু আছে we shall continue on the next day paragraph. The writ petition shall appear under the heading কিসে আছে এটা court application under article 226 on July 29, 2025. তাহলে আলাদা হেডিং করুন কোর্ট অ্যাপ্লিকেশন ব্র্যাকেটে স্পেশালি অ্যাসাইন 226 লেখার দরকার নেই তাহলে আবার ওই কম্পিউটার নেবে না দুটো এক হেডিং হলে কোর্ট অ্যাপ্লিকেশন ব্র্যাকেটে স্পেশালি অ্যাসাইন ঠিক আছে এটা আগে দিয়ে দেবেন যদি আমি কিছু টপ না ফিক্স করি যে সেরা মার্জেন্সি আছে এক্ষুনি ইনজাংশন লাগবে তাহলে এটা উপরে থাকবে অ্যাডভোকেট জেনারেল সাহেব অ্যাপিয়ার করছেন তো এটা উপরে থাকবে তারপর যদি না আমি কিছু ওইরকম ফিক্স করি যে একবারে ইনজাংশন না হলে চলবে না টপ
Or the appearance for the claims has not gone down.
Yes.
It has not gone down.
Mr. Alok Kumar Ghosh. Alok Kumar Ghosh. No, if Kumar is dropped, he gets very angry. Likewise, one just
My lord,
little digression. Mr. Mahata is there in the additional government period. Lolit Mohan Mahata. He gets very annoyed if you write Mahato.
Oh,
He has to be Mahata.
acha.
there may be some reasons I do not know. Mahato or Mahata, maybe some reasons.
Well, I know him from the bad days. খুব পেছনে রাখতাম আছে
Mr. Jointo Mitra, our Mr. Jointo Mitra says that I have abandoned my Kumaratto long back.
But he is still Kumar.
Oh, of course.
He is still Kumar.
Still the handsomest.
Still the handsomest and the still a fit Kumar. Fit for being Kumar. Absolutely. Convey. Thank you. কে হচ্ছে আপনার?
16 নম্বর সিরিয়াল কালকে 20 ছিল।
হ্যাঁ থাকবে।
একদিনই হয়ে যাবে। আমাকে আমি আসানসোল থেকে রোজ আসছি পিটিশন ইন পারসন। আমাকে একদিন একটা
He is appearing in person, my lord. He has some physical problem, my lord. He is coming from Asansol, my lord. He told me.
আসানসোল থেকে রোজ আসছে। কালকেও 20 নম্বর ছিল হয়নি।
You are the other side.
Yeah, no. Well, just 1 minute, my
1
lord.
minute.
Last occasion, same matter, your lordship. His matter was.
All right, I am fixing it.
আজকে যদি নিয়ে নেন তো
My lord, just matter will be, my lord, heard by the cat. So, my lord.
All right, tomorrow I will take it up. I am fixing it.
We have no problem, my lord.
Yes. আপনি কালকে থাকবেন?
হ্যাঁ কালকে
কাল সকালে আসুন। এটা কি আছে মোশনে?
Motion. Item number 16.
Item number 16.
My lord, same matter is your lordship already heard and directed the.
So bring that order tomorrow. Bring that order tomorrow. এটা কালকে মোশন টপে দিয়ে দিন। ঠিক আছে? ওই আপনি মনে রাখবেন 16 নম্বর আজকের লিস্টে। মোশনে আছে?
Yes.
নাকি অ্যাফিডেভিট হয়ে গেছে?
Item number today's my lord, item number 16.
হেডিং আছে একটু দেখুন। মোশনে আছে তাহলে মোশন টপ করে কাল দিয়ে দিন। এই ইন পারসন এসছে কাল সকালে দিয়ে দেবেন মোশনটা। ইউ আর দেয়ার অনলি অন দি আদার সাইড। হ্যাঁ, ব্রিং দ্যাট অর্ডার।
I have come with.
Thank you.
Same person, my lord, same authorities.
Thank you. Thank you. কি দেখে নিন লিস্ট।
I'm for the respondent.
Passed over for the day. Sure.
Procedural is taken. Even a technique book বুঝলাম না। Thank you.